My lord,
Yes.
on the last occasion, your lordship has instructed me to take instruction. My lord, I have the instruction, my lord. However, the second page is not that legible, my lord. Second page of the instruction is not that legible, my lord.
What is the instruction?
My lord, basically the PCC of Eastern Zone, conservation of Chief Conservator of Forest, Eastern Arunachal Circle, Teju, has sought more time because this will need an extensive scrutiny of the documents as well as field survey. My lord, the last page, my lord, these LPCs, their related NOCs and field verification will require a dedicated team specially constituted for the purpose, since the matter of illegal issuance of LPCs by Deputy Commissioner Namsai in RF areas of Namsai since 2010 as alleged by the so-and-so. My lord, here interestingly, even the DC office, the Golden Pagoda and all, that seems to come under the reserve forest. So now, my lord, there are as many as 202 LPCs been given, my lord. Now, whether my lord will direct for verification or instead of directing for verification directly, whether the affected persons need to be included.
No, this is a Mr. Ratan.
Yes, ma'am.
This is a letter of March
Yes, madam.
taking some more time.
Some more time.
April, May, June, July gone by.
Yes, ma'am.
We get the latest instruction.
Yes, my lord, that this is from because the earlier instruction.
How much time is required to verify this? 221 or whatever LPCs? 1 month?
It will take because apart from the
1 month.
scrutiny of the documents, the field verification, actual
month.
field.
1 month.
My lord may indicate at least 2 months, my lord, what
2
the
months.
officers.
Just a moment. 2 months, isn't it?
Yes, my lord.
So 2 months have gone by from the
My lord,
March.
yes, my lord.
We will not grant you 2 months further time now.
My lord, as per this letter, they have sought for terms of reference, my lord. What should be investigated, what should be inquired into, whether that has been done. That serial number 5, precise terms of reference may be given to the committee and power to enter office and residence premises of the. What basically this officer is seeking, that it will not be humanly possible for one officer
What do you say?
Worship, the letter was issued on 3rd March 2023, Your Worship. And wherein the action taken report was sought on within 30 days, Your Worship.
You get the latest instruction. You don't have today.
No, my lord.
By looking
Yes,
at this
sir.
letter itself, you should have sought for the latest instruction.
No, in fact, I also got this instruction very late, my lord.
Ah.
So could not even get the legible copy. Let me have some more time for instruction. Whether any steps pursuant to this letter has been taken by the conservator of forest, my lord.
Where have you indicated, where this letter indicates that even that golden pagoda comes under reserve forest?
My lord will kindly see annexure 3 of the petition, my lord. At page 30. This is
Annexure 3
page 30,
of the writ petition,
writ petition,
not on the instruction,
not only
page 30.
30. This is a RTI reply. The information regarding the same is furnished below. Name of location with geo coordinated. Office of the Deputy Commissioner Namsai, so longitude center. Whether the mentioned land areas comes under reserve forest land or revenue so. The de-reservation proposal of the entire Namsai Reserve Forest was submitted to the government earlier for establishment of Namsai town. If the column 3, my lord, if the land comes under forest reserve land, Namsai Reserve Forest, my lord, 2.5 hectares. And then at page 31, Golden Pagoda. Manabum Reserve Forest, then 19.5 hectares. Then Jain Buddha statue, Lal Pahar Namsai. That also. Therefore, my lord, this will have far-reaching consequences, my lord. At this stage, directly disposing the matter. And those private individuals who have been issued LPC, they are also not made parties, my lord.
Pursuant to order dated 17/7/2023, passed by this court, Mr. Ratan, Additional Advocate General, has produced before this court A letter dated 21/3/2023. Written to the Conservator of Forest Headquarters, Office of the PCC Vitanagar, Government of Arunachal Pradesh, by the Chief Conservator of Forest, Eastern Arunachal Pradesh, Teju. By number so. However, various proposals has been put up to look into the complaint regarding issuance of LPCs to NOCs, land position certificates and no objection certificates in reserve forest under Namsai Forest Division. Also, this is the letter dates back to 21 March 2023. Mr. Ratan Lalit AAG is given for the 1 week time.
1 week.
1 week time to receive the latest instruction from the appropriate authority. Release it on next Monday.
Yes, ma'am.
Release it on 31st, huh?
31st.
31st July. That is Monday, I think.
Yes, ma'am. 31st.
Lordship, can I have the copy of that instruction, Lordship? If
You
Lordship,
furnish a copy.
Yes, sir.
Which one? A copy of the letter dated 21/3/2020 produced by Mr. Ratan Lalit AAG. And I'll list it on.
Always, ma'am.
Yeah, please, Lordship. Lordship, this impugn order is at page 14, Lordship.
What is this IA? I dispose of all.
Yes, Lordship.
Dispose of.
Lordship.
What was the IA for?
One I was for the coronations of delay, Lordship.
Are you sure the IA has been disposed of?
Except other IA is the for stay of the judgment, Lordship. 259, Lordship. I think it's not yet disposed of.
Okay,
Anyway, matter may be taken up, Lordship.
yes.
Since we are ready, Lordship. Impugn order is at page 14, Lordship, annexure 1. Lordship, petitioner was a driver, Lordship, and he was terminated in year 1998, Lordship. Thereafter, Lordship, in year 2016, after more than 17 years, a repetition was filed, Lordship, against that. Thereafter, read petition to consider the repetition, and thereafter, Lordship, another read petition. While considering that read petition, this impugn judgment has been passed, Lordship. Lordship, kindly see the paragraph 7, Lordship, 8 page 18, Lordship. 18, Lordship. The mind of the learned single bench has been reflected in paragraph 7, 8, 9, and 10, Lordship.
Yes.
A reading of the title of TS rules, as well as for the purpose which the rules have been framed, it appears that the rules would be applicable to temporary government servants who are in temporary service. To be in temporary service, the conditions precedent required to be satisfied is that the person concerned must be in a temporary post or officiating in a permanent post. In the present case, going by the order dated so and so, by which the petitioner was appointed, the conditions precedent are not satisfied, as the petitioner was neither appointed against a temporary post, nor he was appointed as officiating in a permanent post. As the impugned termination notice has been made under Rule 5.1 of the CCS TS rules, as the rules itself would not be applicable in case of petitioner. Therefore, the impugned order of termination could not have issued under so and so. The first issue, lawsuit, the petitioner was appointed appointed as a regular lawsuit. Therefore, the terminations which has been done under the temporary rules lawsuit, that would not have been done. That is the past lawsuit case. Then second lawsuit, we have taken note of the commission letter so and so, which gives an indication that even the records are not clear as to whether notice of termination was served upon the petitioner, and also that the notice was not published in official gazette or in any local newspaper. From such point of view also, the terminations of service notice dated 13 to 1998 requires interference. Even if otherwise, the termination notice would have been acceptable in law, but as because it was not served upon the petitioner, it would not have any effect under the law, and nor it would be binding on him. The law in this respect has been considered by the Supreme Court in the case of State of West Bengal versus M.R. Mandal, reported in so and so, wherein in paragraph 16, it has been provided that an order passed but written in file without being communicated to the plaintiff can have no force or authority whatsoever, and the same has no valid existence in the eye of law or claim to have come into operation and effect. No reliance can be placed on the same to even assert claim based on its content. This is the second count lawsuit. Second, mine is the lawsuit, the termination notice, termination order. It was never communicated to the petitioner. That is the second reason given by the London single bench lawsuit. It is stated that the petitioner had retired from service on so and so, and accordingly, upon interference of the order of termination, it will have to be construed that the petitioner would have been in service up to the date of his retirement on 31st 2019. Accordingly, as a consequence of the interference of the notice of termination upon the petitioner, the respondents are directed to provide the petitioner with necessary pensionary benefit as admissible under the rules. We are of the view that the Directorate of Information and Public Relations, Government of Arunachal Pradesh, Nahalagan, had invoked a wrong power or authority to terminate the service of the petitioner, which under the rules would not have been applicable. If there were reason to terminate the petitioner, perhaps it was for the Directorate of Information and Public Relations, Government of Arunachal Pradesh, Nahalagan, to invoke such rules, which would have been applicable for terminations of an employer, but it was not done in the present case. Accordingly, termination notice dated so and so is set aside, but having taken note of the aspect that writ petition was filed in the year 2020, whereas it is a termination notice of the year 1998. Although we are inclined to hold the petition to be maintainable for the reason that medical documents are placed on record, showing that the petitioner was not in an appropriate condition to have approached this court earlier. But at the same time, we are not inclined to provide for any back wages to the petitioner from the year 1998. The third lawsuit, so far delay is concerned, the London single bench has answered. It has been explained by producing the medical certificate lawsuit. So far delay is concerned. These are the lawsuit three grounds on which lawsuit London single bench allowed the writ petition lawsuit.
What about the petitioner?
Driver lawsuit.
Which department?
This IPL also, Information and Public Relations.
IPR.
Yes,
Appointed when?
he was appointed in year 1982, Lordship.
Which date?
Date is Lordship 28/8/1982, Lordship.
28/8/1998.
1982, Lordship.
I'm sorry, 1982. Joined
Yes.
when? Same
Lordship.
date.
No, Lordship. He joined Lordship. Uh, 21/9/1982, Lordship.
21/9/1982.
1982, Lordship.
And he uh, since when he remained absent?
Lordship, he remained absent. Lordship, he remained absent from 15/10/1996, Lordship.
15/10/1996.
Lordship. From this particular date, Lordship, 65 days has to be minus, Lordship. Because he has gone for earned leave, Lordship, 65 days from this date, Lordship. Thereafter, he never came back, Lordship.
From which from 15/6.
15/10/1996.
15/10/96. You know, on from 15/10/96, he availed only for 60
65
days.
days.
65.
65 days.
65 days.
Lordship.
Thereafter, he remained absent.
He remained absent.
Not reported also.
Not reported.
Any proceeding thrown? No proceeding thrown.
Lordship, notice was served, Lordship.
Notice was served.
Notice was served, Lordship. And there was no response. Thereafter,
Under that temporary
rules.
rules.
Lordship. Lordship, so far
Yes.
notice is concerned, Lordship.
There appears to be some dispute on facts regarding service of notice.
Lordship, it has been admitted.
Admitted.
Lost.
Then why did this Rana Singhal just said that?
This is the Lordship. That's what Lordship I wanted to point out, Lordship.
Yes.
Lordship, past issue so far, Lordship, invoking the wrong provision is concerned, Lordship. Because I am on, Lordship, more on technical, Lordship. This is the delay, Lordship. Apart from, Lordship, the second ground, Lordship, notice was not served. Because this judgment has been passed, assuming that, Lordship, this termination notice was never served to the petitioner, Lordship. Lordship, kindly come to the writ petition itself, Lordship.
No, you are addressing the applicability of temporary rules.
No, Lordship. So far, that part is that is more or less is admitted. It seems, Lordship. It was wrong.
He is a regular input.
It seems.
Okay. All right. So second part is what? Notice.
Notice, Lordship. Lordship, writ petition starts from page 24, Lordship, annexure 3.
Yes.
Kindly come to paragraph 9, Lordship. This is a statement, the amendment made by the petitioner himself, Lordship. I'd like to read, Lordship, paragraph 9 and 10, Lordship.
Yes.
That in the meantime, the petitioner got information that his mother had fallen ill and her condition was serious. He immediately applied for 65 days earned leave with effect from 15/10/1996 to 18/12/1996. But unfortunately, his mother suddenly expired at his own hometown. In order to perform traditional ritual as per the local custom, it is pertinent to mention here and that the petitioner also had fallen seriously ill during the period of his mother's expiration, And so he was also immediately taken to the district hospital 0 and admitted in the district hospital 0 with effect from 18/8/1996 to 29/2001. He was diagnosed as suffering from the chronic liver diseases and was under medical treatment in the district hospital 0. It may be mentioned that before expiry of the 65 days on leave, the respondent number 3 had issued, this is lawsuit pertinent, the respondent number 3 had issued notice against the petitioner and asked him to report back for duty positively by 10 February 1997. Otherwise, a discipline action will be taken against the petitioner. Whereas the respondent number 3 did not properly communicate the correct address of the petitioner and gave some other address during his medical treatment, which mentioned here, caused the petitioner a scaring mental trauma, and as such, the process of calculating the 65 days was wrongly calculated by the respondent number 3, which had been done arbitrarily, malabidely with alternative motive lawsuit. This is pertaining to lawsuit, prior termination order lawsuit. He was given this notice. It has been annexed also lawsuit. Now come to the page, paragraph 10 lawsuit. It is pertinent to mention here that the respondent number 3 had issued 2 notices as well as the termination notice against the petitioner under Rule 5.1 of Central Civil Services Temporary Services Rules 1965, without the concurrence approval of the respondent number 1 and 2, respectively, before prior to termination notice. This also is maybe noted lawsuit. It is pertinent to mention here that the termination notice issued by the respondent number 3 was found without having any legal basis, and there was no authority to issue such purported and fake and illegal termination notice issued on so and so, without hearing any file number by the respondent number 3, in spite of the fact that the petitioner, being a regular driver employee of the Department of the Information and Public so and so lawsuit. Here lawsuit, this is the averment of the petitioner lawsuit. He was given the 2 notices prior to termination, asking him to join back, else discipline action would be taken lawsuit. Thereafter lawsuit, the termination notice was issued lawsuit, giving 1 month time lawsuit, which is impugned in the writ petition lawsuit. Now, very interestingly lawsuit, one more thing has been suppressed lawsuit. Lawsuit, after this termination notice has been issued lawsuit, the petitioner joined back, which has been suppressed in the writ petition lawsuit. Kindly come to the page 20 lawsuit.
20 of the writ petition.
Lawsuit. Because in the past writ petition lawsuit, that is 31, WPC number 31 of 2018 lawsuit, by this writ petition lawsuit, this Honorable Court has directed the authority to consider his representation filed in year 2016 lawsuit. Lawsuit, kindly come to page 21. This is a speaking order lawsuit in terms of the passed by this Honorable Court lawsuit. And this speaking order has not been, by this speaking order lawsuit, his claim has been rejected. And in the writ petition, this speaking order has not been challenged lawsuit. Page 21 lawsuit. I'm taking lawsuit to the paragraph 2 lawsuit. Whereas, despite the issuance of the termination notice, there was no response from the Joram Allah, even after expiry of given period. Finally, when the department did not receive any communication from him, Sri Prawat Gogoi, a contingency driver, was appointed on officiating capacity in April 1998. Finally, Sri Joram Allah submitted a joining report on, this may be noted lawsuit, 21st July 1998. in the office of the director of information and public relations, which was rejected by the office in accordance with so and so and so and so. Even after lordship his termination notice, he was aware about the termination notice and he filed a representation lordship. And Lane single bench lordship did not consider that aspect and passed the impugned order lordship, assuming that lordship this termination notice of 1908 was never served to the petitioner lordship. Assuming that lordship the impugned order has been passed, which is the first error lordship committed by the Lane single bench lordship. Now kindly come to page lordship, page 70 lordship, 70. Lordship, sorry, page 69, 69 lordship.
Just a minute.
69 is the lordship, not lordship of the department lordship, by which lordship the representation submitted by the petitioner, which I have referred just now lordship, that has been rejected by the department lordship. Even and this is the part of the writ petition lordship as an annexation lordship, and which has been overlooked by the Lane single bench lordship. Then third ground lordship on which the writ petition has been.
What is page 70?
Page 70 is the lordship. Page 70 is the lordship, the office note lordship. When this honorable court has directed the authority to consider his representation file in year 2016 lordship, then the administrative or the opinion of administrative reform also was taken lordship, and there was a opinion lordship at this stage lordship the case of the petitioner cannot be accepted lordship. Accordingly, the speaking order lordship dated 6 March 2018 was issued in compliance of the order passed by this honorable court lordship.
Yes.
And this is the lordship. So for the one of the error lordship. Now lordship coming to the third ground lordship. So for delay is concerned, which is very pertinent lordship. Lordship, kindly see the medical certificate at page 66. 66 lordship. Page 66 lordship.
66.
66. Annexure 8.
Yes.
Yes, I have read lordship. The Lane single bench lordship hold that lordship, the petitioner was not in position because of his illness to approach this honorable court lordship. This is the one of the mind and the reason cited by Lane single bench lordship. If lordship see that this medical certificate, it certifies that lordship from 18/8/1996 to 29/2001 only lordship, he was suffering lordship. Apart from this medical certificate, there was nothing on record brought by the petitioner satisfying this honorable court lordship for a period from lordship 1998 to 24/2016 lordship, 17 years and 5 months lordship, why he could not approach this honorable court and why he could not approach the authority lordship. That has not been explained at all lordship. In the writ petition, nothing has been brought except for this medical certificate. Even there is no availment lordship. And it's very pertinent lordship.
Not a single report to this medical certificate.
Lordship, kindly come to the impugned judgment lordship. Page 19 lordship. The certificate is not referred lordship, but what the Lane single judge has. I'm taking lordship to the 6th line from the bottom lordship, but having taken note of the aspect the writ petition has been filed in year 2020 whereas it is a termination notice of year 1998. Although we are inclined to hold the writ petition to be maintainable for the reason that medical documents are placed on record, showing that the petition was not in an appropriate condition to have approached this court earlier. This is the lawsuit, the reason given by the learned single bench lawsuit. What I'm submitting is a lawsuit apart from the medical certificate which I have taken lawsuit. There's nothing on record to show that lawsuit that he was medical unfit and was not in position to approach this honor court or the authority concerned lawsuit. Then lawsuit, I'll conclude my lawsuit submission by placing one judgment lawsuit.
On which points?
Delay lawsuit, delay in legislation. In this case, lawsuit, the petitioner was the husband of the petitioner was lawsuit terminated in year 1996 lawsuit. 96 lawsuit. In year 2012, that is after 15 years lawsuit, writ petition was filed in year 2012 lawsuit. The learned single bench allowed lawsuit, division bench also allowed because there was a non-compliance of the lawsuit one, principle of natural justice lawsuit. Now, that has been answered in paragraph 7 and 8 lawsuit. 7 lawsuit.
Yes.
Considering the opposite facts and circumstances, as such, the learned single bench ought not to have entertained the writ petition in the year 2012, challenging the order of termination passed on 16/12/1996 on the ground of delay and laches allowance. At this stage, it is required to be noted that even despite the fact that it was specifically prayed by the respondent in writ petition before the learned single bench to direct the authority to decide the appeal prepared by her husband, the learned single bench, despite the above prayer and the pending appeal, enter into the merit of the case and quash and set aside the order of termination dated 16/12/1996. The submissions on behalf of the respondent is that terminations on 16/12/1996 was absolutely illegal and against the principle of natural justice is concerned. Once we hold that the writ petition was barred by delay and laches, thereafter the merits are not required to be considered also. So this is the lawsuit delay. Here lawsuit 15 years lawsuit after termination notice lawsuit. But in present case lawsuit 17 years and lawsuit for 5 months lawsuit. And case is also not lawsuit. The petitioner was not aware about the termination notice lawsuit. Yes, I took lawsuit to the representation after termination lawsuit, which was not considered by the learned single bench lawsuit. That's all lawsuit.
Make the lawsuit. I know the notice issued by the respondent authorities under Central Service Temporary Service Rule 1965, madam. Rule 5, Clause 1, which clearly laid down that.
That's a wrong provision.
Yes.
That is not applicable.
So on the basis of that, actually the petitioner was not allowed to join in service, madam. Number one, right? The Rule 5 says termination of temporary service. A, sub clause, small letter A. The service of a temporary government servant shall be liable to termination at any time by a notice in writing given either by the government servant or appointing authority, or by the appointing authority to the government servant. B, The period of such notice shall be 1 month. My lord, as per this rule, as provided by the CCS rules, Temporary Service Rule 1965, certain conditions are there, my lord, which I would like to appraise you, lordship, my lord. As my learned friend has just brushing aside the main ingredients of the rules. Rule, sub-rule 5(1) A, B, C, which has not been complied, my lord. My lord, may I read? B, provided that the services of any such government servant may be terminated forthwith by payment, my lord, payment to him of a sum equivalent to the amount of his pay plus allowances for the period of the notice at the same rate at which he was drawing them immediately before the termination of his service, or as the case may be, for the period by which such notice falls short of the 1 month. Then, my lord, other conditions are there. I would like to mention before your lordship is that all conditions have not been fulfilled by the respondent authorities. Number one, that the notice shall be delivered or tendered to the government servant in person. In the instant case, my lord, the respondent authority did not serve the notice in person, this which is illegal. And
But you, after you were terminated, you tried to join on 21st July 1998.
thereafter also, my lord.
After
Thereafter also, my lord.
thereafter also.
Yes,
So that which means you had the knowledge of your termination order from the service. And you did not approach
he
the court.
heard about the notice, termination notice, but he did not receive the notice.
You face fresh departmental proceeding.
My lord, let me complete my submission, my lord. So, when the my lord, the notice was not properly served upon the government servant, and this is not as per the order of the Rule 5, Sub-Rule 1, A, B, C. Now, my lord, number 3, Sub-Rule 3 is, if the notice sent by the registered post is returned answered, it shall be published in the official gazette, where my lord, for which my lord, the respondent authority did not act upon such provisions. It should be published in the official gazette, and upon such publication, it shall be deemed to have been personally served such government servant on the date it was published in the official gazette. So as per the rules, it was not done, which is illegal, my lord. A person cannot be terminated without my lord showing cause, which is completely illegal. It is a violation of the principle of natural justice, my lord. Then, my lord, 2(1) small letter A, where a notice is given by the appointing authority terminating the service of a temporary government servant, or where the service of any such government servant is terminated either on the expiry of the period of such notice or forthwith by of payment of pay plus allowances, the central government or any other authority specified by the central government in this behalf may of its own motion or otherwise reopen the case, my lord, which was not done by the authority, man. This is also completely illegal. Then, my lord, case, and after calling for the record of the case, and after making such inquiry, it deems fit, confirm the action taken by the appointing authority. Then only, my lord, they can confirm the termination order as legal. Then, my lord, B, small letter is to withdraw the notice. Then they can withdraw it. Then reinstate the government servant in service or make such other order in case as it may consider proper, provided that except in special circumstances which should be recorded in writing, no case shall be reopened under such sub rule after the expiry of 3 months. This was also not done by the respondent authorities, my lord. And number one is that the notice should be given to the government servant personally, through messenger or any other form, which was not done. Number two, no official gazette was published. Then third condition, my lord, it should be published in the newspaper. They have not done it, my lord. So, my lord, Annexure 1 of the writ petition, my lord, page 28.
You are arguing for a disposal. We are ready for that. We can dispose it of. If you are finally advancing your argument for disposal, we will hear you.
My lord, actually, if some difficulties, then no problem. But I shall make my endeavor to do my best.
No, you are. There's no doubt you are doing your best. The court is asking, you are arguing for a disposal of the case.
If my lord, if your lordship deem fit and proper manner, then let the my lord, argument, a hearing of the argument be fixed.
No, choice is yours. You are free to argue also. We are ready for disposal also. If you are arguing for disposal, we will hear it. And if not, we will admit and stay the judgment of the London Single Judge. And we will hear you in the when the matter is called up for hearing. Listed for hearing. We are probably say.
Okay, my lord, let the matter fixed for hearing.
No say.
We are probably satisfied that there are substance in the appeal. Okay. And Mr. Piso, learned to answer for the respondent. Admit, call for the record. Please to notice to the respondent. Since the sole respondent, so great petitioner is represented by Mr. Tison on the council for the Lani council. No formal notice. This said. What did you say? Issue notice, return 4 weeks. Yes, Mr. So-and-so, no conversations. In the interim, the impugn judgment and order dated 2022. Passed in WPC 370 of 2020. Still remain step.
In the meanwhile,
Otherwise, I was expecting for loss disposal loss.
meanwhile, my lord, I have a request that let the case record be called for back, original case record of the service book of the petitioner.
Yeah, lordship, what happened, lordship?
Yes, it
There's
is
a part of
mandatory, my
the
lord.
part of the pleadings, lordship. Service records of the petitioner gone missing, lordship.
That is
and-
we do not know.
FIR has been lodged, lordship,
That we do
and
not
matter
know.
is under investigation.
And this may be produced, my lord.
No, those states are gone. We are in a appellate stage. We have to test the legality of the other single judge's order. We are not going to go into the facts now.
I don't know, unless single judge has opined that there is a missing of the service book of the petitioner. So without having the service book, it will be one of the difficult.
What is the discussion on the service book missing? In the,
That is not there, lordship. Service book of the petitioner was lordship, sent from the zero, lordship, and it was not received by the director, lordship. That is the situation of your lordship.
And my submission may be recorded because service book is most essential.
Otherwise, lordship,
see,
since my senior print is ready, so it can be disposed also, lordship.
you will have to departmental proceeding will have to be drawn.
Lordship.
You did not draw up a departmental proceeding.
Lordship, notice was served.
See, you issued a notice on the temporary service rules.
Correctly. That
He-
notice was not issued under the temporary rules, lordship. It was a notice without referring any provision, lordship.
Okay.
He was directed to join back, lordship, as departmental.
That is notice for what? Termination.
Termination, lordship.
Are you not required to draw up a departmental proceeding against him?
Lordship, seems he has admitted, lordship, so accordingly termination notice.
It can't
He-
be. See,
He chosen not to, lordship, contest, lordship.
if he is a temporary employee and you are invoking that rule 5 of
Five
the-
temporary rules.
then departmental proceeding is not necessary. Is not it? 1 month notice or something like that. But he is a regular employee.
Lordship, therefore, lordship, the delay in leches, lordship. Just I,
See, delay in laches for what? For giving him after setting aside the termination order
lordship.
to put him back on the service. Back on the service means since he has already retired for the purpose of giving pension, etc. Is not it? But even if we interfere with this order
Lordship.
of the learned single judge,
Lordship.
and we'll have to say that termination order was issued illegally without following the due process of law.
So therefore, lordship, in this the citation which I have placed, lordship, there also some sort of that
Delay.
procedure was not followed, lordship. On that count, that was challenged, lordship. Honorable Supreme Court said, lordship, when lordship the issue is decided on lordship technical, that is the delay in leches, lordship. Merit is not necessary to be gone into, lordship.
So better we examine this matter.
Lordship.
Mr. Song,
Yes,
is not it? You have got this.
Yes, sir.
So the provision which you are referring to may not help you. Since they admit that you are a regular employee, they may have to do up a departmental procedure, something like that. After 4 weeks.
Of like.
Item number 3.
Please, your lordship.
Hmm.
So as we have specifically taken the ground in our affidavit that matter is already subsidized before the Honorable Supreme Court. The same and similar matter issue was raised before the Gujarat High Court, madam. And again, that against that matter judgment and order, madam, Union of India prepared the SLP before the Honorable Supreme Court. Now same is state and same is pending before the Honorable Supreme Court. So therefore, at this stage, madam, till the outcome of the matter and the disposal of that SLP.
Hmm.
Madam, it's
Yes,
for
so
6
this-
weeks.
What is that SLB?
And para 6.
6.
Last paragraph.
Okay. Art STY Butil or counsel for the petitioner and Mr. M. Kato or the DSTY, who were referring to the evidence in opposition filed by which respondent?
Union of India, madam.
Filed by the Union of India. Has pointed out that the issue raised in this petition is pending consideration by the Honorable Supreme Court in a special leave petition civil diary number within bracket S 40304/2019 at page 6 of the agenda. Poster, he accordingly placed for listing of this matter after the aforesaid SLP is disposed of by the Honorable Supreme Court, to which proposal Mr. T.Y. Bhutia, along with counsel for the petitioner, has not objected. In view of the above, this matter, you will point out,
Yes,
this petition, as and when learned counsel for the other party advises the registry of this court
madam.
regarding the disposal of the SLP, the aforesaid SLP.
Your Honor, there are also two other similar matters, WPC 471 and 472, which they've not been listed today,
Okay.
but they may be listed along with this case as and when it comes up. Usually they used to be listed together, but today it's not been listed. WPC 471 and 472.
It would be appropriate if we
They were
pass-
filed together.
It would be appropriate if we pass order when the matter is listed.
Okay,
Isn't it? Whenever those matters are listed, we'll pass the same order.
okay,
Then you point out the order of this one. Pass today.
okay. Okay.
Development.
Lordship, matter may be adjourned for today, Lordship.
Which one?
We are very sorry, we could not take steps to the private respondent as per the
Steps
direction of
to whom?
steps to private respondent. Complainant,
It's a POXO case, your lordship.
POXO cases,
Oh. You want to take steps?
yes.
In view of the published note dated 21/7/2023, Mr. Tapak, counsel for the applicant. I is for condonation. I is for what?
I is for condonation of delay period in filing the
Press for applicant, press for it is granted 1 week time to take the steps upon respondent number 2. But I still procedure is the usual process. Listed after 4 weeks.
Lordship, one more mention, item number 6.
Yes,
That may also be adjourned for today because after matter may fix after 2 weeks.
after 4 weeks.
2 weeks,
Why?
because my party wanted to appear to senior,
Hmm,
that is.
Okay.
he is not here.
6 on the prayer of Mr. T. Tapak. Council for petitioner listed after 2 weeks. Outline.
And in this case, I'm appearing on behalf of Mr. S.K. Deoli.
Yes,
I've been instructed that I submit before this honorable board that respondent number 6 and 7 be struck out from this IA as well as the appeal, Your Honor, because they've been added inadvertently. Because
where is Mr. Devi?
he could not be present today.
And after it is struck of them, what is to be done to the IA? What this IA is for?
IA is for condemnation of delay.
Conversion of delay.
On the last occasion, respondent number notice was issued to respondent number 5.
You file an application for striking off.
Okay, Your Honor. Yes.
On the prayer. On the prayer of London Council. On the prayer made on there, Mr. S.K. Deoli, London Council for the applicant listed after 4 weeks.
Matter may be fixed on 2nd of August, Your Honor.
After
So
2
that-
weeks.
They may appear.
He will have to file an application.
No, for the hearing of condemnation, and then on the same day, the application will be filed.
After 2 weeks, 2 weeks.
Okay. All right.
Ma'am, please. Hello, this is jail appeal, ma'am. Appellant was convicted under section 302 IPC. ma'am, and sentenced to undergo, my lord, 20 years, my lord, life imprisonment. I'm sorry, ma'am. Life imprisonment.
Section
302.
302.
Yes, ma'am. Ma'am. My lord, subject to your lawsuit consideration, ma'am. My lord, in this case, my lord, my humble submission is that, my lord, in this case, my lord, further, my lord, evidence,
This is a jail appeal.
jail appeal, ma'am. My lord,
Notice to the informant and victim is not necessary.
my lord, I think informant is not made for him.
What is the position now? Informant is to be
My lord,
served notice.
in my humble submission, my lord, not in every case, my lord. In POCSO, my lord, it is
Not in 302.
not in 302, my lord. That's why my lord, humble.
Yes.
Yes. My lord, what I am submitting is that, my lord. My lord, subject to your lawsuit consideration, my lord. My lord, in my humble submission, my lord, this case, my lord, needs further evidence.
Further evidence.
Yes, my lord. Why I am submitting so, my lord? My lord, this, my lord, the impugned judgment, judgment and order passed by the, my lord, London Session Judge, my lord. Conviction was based on, my lord, confession made by the appellant under section 164.
Confession.
Confession, my lord. And that confession has been, my lord, retracted, my lord, by the appellant in 313, my lord. Examination of, my lord, accused person under 313. That has been retracted, my lord. Now, my lord, when, my lord, confession, my lord, is retracted, my lord. My lord, it is a rule of, my lord, prudence that it should be, my lord, corroborated by other evidence also, my lord. Court has to look into the other evidence, whether it is corroborated to it or not. Here in case, my lord, the other evidence which is corroborated, tried to corroborate it by the prosecution, is regarding, my lord, the recovery of my lord, this murder weapon. My lord. As per my lord version of the prosecution, my lord, the offense of murder weapon was, my lord, recovered from the house of the accused person, my lord, on house search, my lord. It is not a case that, my lord, it was recovered under, my lord, section 27 of Evidence Act, my lord. And thereafter, my lord, after recovering that, my lord, murder weapon, my lord, it was, my lord, sent for FSL, forensic, my lord, report, my lord. And the forensic report, my lord, this murder weapon, as well as, my lord, this blood traces of the victim, my lord, was sent to FSL, my lord. Thereafter, my lord, there was report of the FSL, my lord. FSL report is that, my lord, there is traces of blood in, my lord, human blood in the weapon, my lord, which is sent for, my lord, FSL. But, my lord, blood group was not detected, my lord. So it cannot be compared with the blood group of the victim.
Blood sample was not.
Blood group was not detected. Though, my lord, in the weapon, my lord, the sample of, my lord, blood traces are found, my lord. Human blood traces are found. But blood group cannot be detected. Therefore,
By the FSL report.
yes, my lord, FSL report. Therefore, it cannot be, my lord, compared with the blood group of the victim, my lord.
Okay.
And, my lord, that person who has been, my lord, who has, my lord, made the report of FSL, my lord, that has he has not been called for the landed court, my lord. And in my humble submission, he ought to have been called, my lord. So that, my lord, my lord, during the trial, my lord, the person who has made this report, my lord, he has not been called as a witness, my lord.
Okay.
My lord, he ought to have been testified before the landed trial. My lord, why? My lord, this in the report, he has mentioned that though human blood is detected, but blood group cannot be, my lord, ascertained, my lord. And therefore, it cannot be, my lord, compared with the blood group of the victim, my lord.
Weapon was recovered when?
My lord,
You said
uh,
during the course of investigation.
yes, during the course of investigation.
House search made.
Yes, on the house search, my lord. And after that, it was sent for FSL, my lord, along with the blood group of the victim. My lord, in my humble submission, my lord.
This has been one of the basis for conviction.
Conviction, my lord. And, my lord, the one, my lord, medical, my lord, report is there, dear, my lord. That is also, my lord, taken into consideration.
What is that medical report?
Medical report is, my lord, regarding, my lord, the injury received by the deceased person, my lord. That is dear, my lord. And, my lord, one more important thing, my lord, when this house was searched, my lord, 4 person was made witness, as in seizure witness, my lord. And during, my lord, during the trial, my lord, only 2 person has been called as a witness. And that 2 person, first one is the complainant, second one is the murder of the victim, my lord. But other 2 independent witnesses, my lord, who are, my lord, part of the, my lord, search and seizure, my lord, they have not been called as a witness before the landed trial court, my lord. So in this, my lord, backdrop, my lord, I am, my lord, asking for, my lord, remand back the matter back to the landed session judge. These 3 vital witnesses may be, my lord, examined, my lord, so that, my lord, it can be conclusively, my lord, proved that the murder has been, my lord, committed by the victim, my lord. Otherwise, my lord, benefit of doubt will go to, my lord. Therefore, I am, my lord, submitting, my lord, in my humble submission, my lord, subject to what your lordship consideration, my lord. Being an amicus, my lord, I am submitting this. My lord.
when direction for press examination of witness or evidence, recording of the press evidence can be issued by this court. And
One of the-
which provision and under what circumstances?
The power of the appellate court, my lord. The power of the appellate court, my lord. My lord, the CRPC, my lord. My lord, 391, my lord, section 391, my lord, criminal code of criminal procedure. Section 391. my lord. Appellate court may take further evidence or direct it to be taken. My lord, it's reads like that, my lord. In dealing with an appeal under this chapter, the appellate court, if it is thinks additional evidence to be necessary, shall record its reason and may either take such evidence itself or direct it to be taken by a magistrate. Or when the appellate court is a high court by a court of session or a magistrate. My lord, subsection 2, when the additional evidence is taken by the court of session or the magistrate or it, or he shall certify such evidence to the appellate court, and such court shall thereupon proceed to disposal of the appeal. The accused or his pleader shall have the right to be present when the additional evidence is taken. The taking of evidence under this section shall be subject to the provision of chapter 23 as if it were an inquiry.
This provision does not say about remanding the matter for additional evidence.
Yes, my lord, there
It is take,
yes, my lord. My lord, we can also come to my lord, section 386. That is power of the appellate court. My lord, section 386, my lord, power of the appellate court. After perusing such record and hearing the appellant or his pleader. If
What
he-
is the difference between 386 and 391? Insofar as the recording of evidence is
yes.
concerned,
My lord,
further evidence is
my
concerned.
lord, in 391, my lord, pending consideration of appeal, my lord, before this honorable court. My lord, this honorable court may direct. the
Recording of
magistrate-
further evidence
Yes, my lord. And that evidence will be taken together in this.
in the appeal.
Yes, my lord. In 386, my lord, it can be remanded back, my lord. After setting aside the judgment, my lord, it can be remanded back for my lord, retrial. Or press trial. That is my lord, wording of the
Okay.
section 386, my lord. After perusing such record and hearing the appellant or his pleader, if he appears the public prosecutor, if he appears, and in case of an appeal under section 377 or section 378, the accused, if he appears, the appellate court may, if it considers that there is no substantial ground for interfering, dismiss the appeal or may, in appeal from an order of acquittal, reverse such order and direct that further inquiry be made or that the accused be retried or committed for trial, as the case may be, or find him guilty and pass sentence on him according to law. B, in appeal from a conviction, reverse the finding and sentence and acute or discharge the accused or order him to be retried by a court of competent jurisdiction subordinate to such appellate court or committed for trial, or alter the finding, maintaining the sentence, or with or without altering the findings, alter the nature and the extent or nature and extent of the sentence, but not so as to enhance the sentence. B, my lord. Subsection B is a relevant.
Which is the provision for remanding back for further evidence?
My lord, the subsection B, my lord.
Subsection B.
Yes, my lord.
In an appeal from a
conviction. My lord. Reverse the finding and sentence and acquit or discharge the accused or order him to be retried.
Okay, retried.
Yes, my lord. By a court of competent jurisdiction subordinate to such appellate court or committed for trial, or
Yes, can you elaborate something on this?
my lord,
When such retrial can be ordered by this court? By the same court which court had convicted,
yes, my lord.
by the same court which had
Convicted
convicted the appellant.
appellant,
Huh?
yes, my lord. To that court, my lord. It
Ah.
can be my lord, sent back.
Yes,
Or my lord, it can be, my lord, 391 can be invoked, my lord. Either of two can be invoked with this honorable court, my lord, in my humble submission, my lord.
under what circumstances?
My lord, I have, my lord, place that, my lord, conviction was made on the basis of confessional statement, my lord, given by the accused person, my lord. And that has been retracted, my lord. And my lord, if the confessional statement is retracted, my lord, my lord, some corroboration will be necessary, my lord, material corroboration. My lord.
Hmm.
In this case, my lord, the my lord, corroboration, my lord, the learned session judge has taken corroboration
Then
regarding
if it is not corroborated,
benefit of doubt.
benefit of doubt will go to the accused.
Go to the accused.
Then why not we extend that benefit of doubt and why
No.
should we? Huh?
My lord, I have already submitted, my
No,
lord.
no, that,
Yes, my lord.
see, that is what we are asking.
Yes, my lord.
See, there may be circumstances
Yes, my lord.
under which further evidence can be directed to be taken
Yes,
or maybe sent back for a retrial
yes, my lord.
without extending the benefit of doubt. Now, what are those circumstances? Since we have pointed out two provisions,
Yes, my lord.
and we would like to know the difference and the difference of circumstances contemplated under 386 and 391.
Yes, my lord. My lord, in this, my lord, in this case, my lord, the three witnesses, it ought to have been, my lord, their evidence ought to have been taken by the learned session judge, my lord.
Hmm.
That is my lord, what I'm trying to something like that, my lord. Otherwise, my lord, benefit of doubt, my lord, can be given by this court also. In order to, my lord, bring the substantial justice, my lord. That ought to have. Therefore, I am submitting.
Hmm.
Otherwise, my lord, this court is, my lord, ample power to give a benefit of doubt to the accused person, my lord.
Let us see that provision that unless corroborated,
Yes, my lord.
confession retracted. If not corroborated by other evidence,
my lord, paragraph 16 onward, my lord. 11th will be, my lord. Start from, my lord, 17, my lord. Paragraph 6, 17, my lord. May I read, my lord?
Yes.
Having thus reached a finding as to the voluntary nature of the confession, the truth of the confession should then be tested by the court. The fact that confession has been made voluntary, free from threat inducement, can be regarded as presumptive evidence of its truth. Still, there may be circumstances to indicate that the confession cannot be true wholly or part, in which case it loses much of its evidentiary value. 18. In order to assure of the truth of the confession, this court in a series of decisions has evolved a rule of prudence that the court should look to corroboration of other evidence. However, there need not to be corroboration in respect of each and every material particular. Broadly, there should be a corroboration so that confession taken as a whole fits in the facts proved by the other evidence. In substance, the court should have assurance from all angles that the retracted confession was, in fact, voluntary, and it must have been true. The law on the subject of retracted confession has been succinctly laid down by a three-judge bench of this court in such and such, reported and such, which lay down. The next question is whether there is a corroboration of confession since it has been retracted. A confession of a crime by a person who has perpetrated it is usually the outcome of penitence and remorse, and in normal circumstances is the best evidence against the maker. The question has very often arisen whether a retracted confession may be form of basis of conviction, if believed to be true and voluntarily made. For the purpose of arriving at this conclusion, the court has to take into consideration not only the reason given for making the confession or retracting it, but the attending facts and circumstances surrounding the same. It may be remarked that there can be no absolute rule that a retracted confession cannot be acted upon unless the same is corroborated naturally. It was laid down in certain cases, one such being in such and such, reported and such, that if the reason given by an accused person for retracting a confession are on a face of them false, the confession may be acted upon as it stands and without any corroboration. But the view taken by this court on more occasions than one is that as a matter of prudence and caution, what is sanctified itself into a rule of law. A retracted confession cannot be made solely the basis of conviction unless same is corroborated one of the latest cases being such and such, reported and such as. But it does not necessarily mean that each and every circumstances mentioned in the confession regarding the complexity of the accused must be separately and independently corroborated, nor it is essential that the corroboration must come from the fact and circumstances discovered after confession was made. It would be sufficient in our opinion that the general trend of confession is substantiated by some evidence which will tally with what is contained in the confession. Thereafter, my lord, I will skip rest, my lord, in paragraph 19, my lord, in parallel case. Yes, my lord, paragraph 19, my lord. In parallel case supra, the same principle is regard to the evidentiary value of retracted motion has been reiterated. Justice Subara, speaking for the four judgments, stated the legal position thus. A retracted confession may form the legal basis of a conviction if the court is satisfied that it was true and was voluntarily made. But it has been held that a court shall not base a conviction on such a confession without corroboration. It is not a rule of law, but it is only a rule of prudence. It cannot even be laid down as an inflexible rule of practice and prudence that under no circumstances such a conviction can be made without corroboration. For a court may, in a particular case, be convinced of the absolute truth of a confession and prepared to act upon it without corroboration. But it may be laid down as a general rule of prudence that it is unsafe to rely upon such confession, much less on a retracted confession, unless the court is satisfied that the retraction confession is true and voluntarily made and has been corroborated in material particulars. By the use of expression corroboration of material particulars, the court has not laid out any proposition contrary to what has been clarified in Subramaniam Bodhan case. As regard the extent of corroboration required, the above expression does not imply that there should be a meticulous examination of the entire material particulars. It is enough that there is a broad corroboration in conformity with the general trend of the confession, as pointed out in such and such case.
Yes.
Well, in this case, my lord, the accused has been acquitted, my lord. I'm giving benefit of doubt, madam. My lord, if I proceed further, my lord, my lord, on this back, my lord, legal proposition, my lord, I will take your worship to FIR, my lord. Copy of the FIR.
Yes.
May I proceed, ma'am?
Hmm.
Hello, the copy
How
of
many
the,
witnesses are there?
there are altogether, my lord, 7 witnesses. Ma'am.
7 PWs.
Yes, ma'am. Yes, ma'am. May I proceed? My lord,
But you said conviction is based on confession.
confession, my lord, and my lord, witness of PW 5 and 6.
5 and 6.
Yes, my lord. They are deposed before the court, my lord. On the death day, my lord, they have seen the accused person near by place of occurrence, my lord. But they have not seen, my lord, committing the crime offense. But and my first, my lord, I'll take your also to FIR, copy of the FIR,
Yes.
page 1.
Yes.
With due respect and humble submission, I have the honor to inform you that, sir, on 19/9/16, my sister such and such went to our paddy field for harvesting paddy at around such and such time after school break. Till this morning on 29/16 at around 9:30 hours, she did not return back home as she was searched out for my sister, missing sister, such and such, daughter of such and such, Christian was. So, no. During search, I found the dead body at Tokopata Garden, around 200 meters, approximately 12 east from the house, in the jungle under Christian chalk blaze. It is seen that multiple sharp cut injuries on head and throat, which is a case of murder. Therefore, you are requested to look into my matter and take up investigation. On the basis of this FIR, my lord, the case was registered, my lord, against an unknown person, my lord, and investigation was taken up. Thereafter, my lord, the accused has been arrested, my lord, and my lord, from on house search, my lord, which is at page 27. This is house search memo, my lord, page 27, my lord. House search was made on my lord 21/9/16, page 27, my lord. Today, 1/21/9/16 8 such and such hours, I, Sri such and such, PS conducted house search in the sleeping bed of Sri Suresh Maji, such and such, such and such, in presence of below number of blazer of the Christian chop, in connection with above noted case, reference to M2 PS, and during such his sleeping bedroom, the dao of Suresh Maji was recovered, which was hidden inside the roof Tokopata leaf. My lord, signed witness, my lord, is my lord Sri Manuel Jatarma, Sri Bosco Puti. This is the my lord signed witness, my lord. And thereafter, my lord, search my lord, seizure list was prepared, which is page 26, my lord. Page 26, my lord. This is the seizure list, my lord. Page 26, seizure list. I say such and such. Here was seized below descriptive. I'm sorry, my lord. Sorry, my lord. This is house search memo is 27. Is my lord 25. I'm sorry, 25 is the my lord, seizure list of down. I Sri such and such, my lord. Do hereby seize the dao of Sri Suresh Mazi, age about 18.5 years, son of such and such, Blaze Krishan Chok in case wise of the items in presence of denoted witness. Discretion of seized dao. My lord, there are the name of the seizure witnesses. One, my lord, Barna Karia. My lord, this is the complainant, my lord. Two, Nicholas Karia, father of the deceased. And my lord, Sri Bosco Purti and Sri Manuel Chotora Mama. They are, my lord, independent witnesses. Thereafter, my lord, after my lord sees this, my lord, mother weapon, my lord. Some blood traces are, my lord, found on that down. Therefore, my lord, it is sent for FSL, my lord, report, my lord. And after, my lord, conducting the FSL, my lord, the report was submitted to the judicial magistrate, my lord. The report is 8, my lord, page 33 to 35, my lord.
Hmm.
33 to 35 minutes. This is the FSL report, my lord. Sent to the, my lord, judicial magistrate first class, Lekang, Namsai district, Arunachal Pradesh. Page 33. It is short from page 33, my lord. Relevant is at page 35, my lord. Dated 25 January 2017, my lord. Description of exhibits. Page 35, my lord. Description of exhibit. Exhibit A, dao. Blackish stain on the sharp end of a wooden handle dao. Exhibit B was not opened in the laboratory. Exhibit B is the sample of blood, my lord, of the victim. Result of the examination, my lord.
Exhibit B is the
My lord, blood sample of the victim. Blood sample of the victim.
this is
Yes, ma'am. This is ma'am. Result of the examination, ma'am. The above exhibit was examined by tetramethyl benzidine test and Takayama test for the blood detection of blood. Further, the blood positive exhibit was analyzed by gel infusion method and absorption illusion technique for detection of origin and avio grouping respectively. On the basis of above examination, it is concluded that human blood could be detected in exhibit A. I would kindly note it, man. Human blood could be detected in exhibit A. Blood could not be detected in exhibit A. Hence, it cannot be compared with exhibit B. When human blood is detected in exhibit A, but my lord, blood group, my lord, cannot be, my lord, detected in exhibit A. Hence, it was not compared with exhibit B, my lord. Thereafter, my lord, Again, my lord, now I will take lordship to confessional statement, my lord, recorded by the my lord, magistrate, my lord, Honorable Magistrate Mahadevpur, my lord, which is at page 31, my lord. Page 31, start from my lord, page 31, my lord. In the Court of Judicial Magistrate First Class, Mahadevpur. My lord, kindly note, my lord, Sri Suresh Mazi, produced by the OC Police Station, Mahadevpur, before me on 7/10/2016 to record his or her statement in connection with Mahadevpur case number 25/2016 under section 164 CFPC. My lord, down below is a consignor, my lord, put to the accused person by the, my lord, magistrate, my lord, who was recording the confessional statement of the accused. My lord, the next page is 32 is the, my lord, memorandum of confirmation, my lord. What the accused is confessed before the magistrate, my lord. We are in love with each other 3 years since. In between the time we enjoy such also. 5 months back, she informed me of complication on her S. I was shocked and afraid hearing the fact. I was not thinking of marrying her, but afraid of her pregnancy, which might compel me to marry her. Instantly, I planned to murder in a suitable time. After that, 5-6 months passed. I and the girl such and such were enjoy such relation between also. On 19/9/2016, at around 2:30 p.m., I came back from school and after having lunch, I went for grazing field in search of my cow at about 3:30 p.m. On the way, I found such and such also in the field, and she called me to come. I came to her, and both again enjoyed such in the ground. Nobody was seen this at that time. After that, I got up, and what happened to me that I could not understand. Suddenly, I took out my dog, which I had taken with me from home, and hit her on the neck, and thereafter I twice hit her on head. Thereafter, I came back to my house at about 4 p.m. On 21/9/2016, police raided my house and took me in custody and brought me to police station. Thereafter, they formally arrested me and put me in custody. And my lord, after that, my lord, the next, my lord, the necessary documents will be the, my lord, medical examination, my lord, postmortem report of the, my lord, disease, my lord, which is at page 28. Page 28, my lord, postmortem report, my lord, of the disease, my lord. Page 28, my lord. Yes, my lord. Exhibit 6, page 28. My lord, second column, my lord. External appearance, my lord. Incised found on forehead, length 3 inch, depth 1 centimeter, and inside on scalp posterior region, length 5 inch and depth 1 centimeter.
Where are you reading?
My lord, down below, my lord, external appearance, my lord. My lord, column 2, to one's position, size, and character, my lord. Inserts wound on forehead, length 3 inches and depth 1 centimeter, and inserts on skirt, posterior region, length 5 inches and depth 1.5 centimeter. And my lord, next is postmortem report of thorax, my lord. My lord, the next is my lord, postmortem report of thorax, my lord. Column 3, my lord. Trachea cut. Trachea cut. Thereafter, my lord, the fourth is abdomen, my lord. Esophagus cut off. My lord, the page 30, my lord. This is the my lord, detailed, my lord, report of my lord, injury sustained by the deceased person, my lord. 30, my lord, more detailed description of injury or disease. This is trachea cut off and esophagus cut off. Deep incisive wound on forehead and posterior region of the skull. Therefore, my lord, opinion of the my lord, this the person who has conducted postmortem, my lord. The cause of death could be due to cut off of trachea, esophagus by sharp weapon, which is
Esophagus, this neck part.
my lord, this is a foot pipe. Oh, foot pipe. Homicidal in nature. Time of death 14:30 to 25 hours. My lord, on the basis of these documents, the charge sheet has been filed, and trial has been conducted by the London Session Judge, my lord. And first, my lord, I will take your lordship to the my lord deposition of PW1, which is 8, my lord, page 49. Start from page 49, my lord.
Is the complaint, is the information.
Complainant.
Yes.
My lord, on out, page 49, my lord. I can recognize the accused person standing on the dock is Suresh Maji. Though I have forgotten the date, month, and the year of the incident, so far I remember same took place on Monday. I'm the older brother of deceased late still such and such. On the day of incident, when I arrived at home, found the deceased absent in my house. And accordingly, I went in search of her, but she was not found. On the next morning, when I again went up for search, found my deceased sister lying dead in the Tokobari. Having seen the same, I started shouting and fell unconscious. I regained my consciousness in hospital. When I arrived at home, I found the dead body of my deceased sister kept in courtyard of my house. Accordingly, I reported the matter to police. The paper was adopted by police on my instruction. I have witnessed the inquest conducted by the police. And also I have witnessed the seizure of sickle, tokopata, dao, and such. They are after my exhibit, my lord, not to be necessary, my lord. And the cross has been declined. My lord, by the my lord, testimony of this PW1, my lord, nothing can be drawn against the accused person, my lord. Only he is a complainant, my lord. He is not, my lord. Says anything. Therefore, he is not so relevant, my lord. My lord, next is my lord PW2, my lord. He is the father of the victim girl, my lord. Father of the victim girl, my lord. This is so, my lord. Nicholas Correa, my lord. my lord, they are, in fact, my lord, they are the seizure witness, my lord. I will come later to become the seizure witness. My lord, regarding their deposition in the court, their my lord, this PW2, my lord, testimony is not also, my lord, so much of relevance, my lord, because the learned court, my lord, the session judge has, my lord, rely on the deposition of PW 5 and 6.
Okay.
Page 55, my lord.
Who is 5?
5 is, my lord, A Manpong, my lord. My lord, on that day, my lord, the accused used to, my lord, gaze her cattle, my lord, in the field, my lord. The accused used to gaze her cattle in the field for this person, my lord.
In whose field? This in the field of respondent number 5.
Yes, my lord.
Okay.
And on that day, my lord, the accused was asked to cut a tokopata leaf from the garden, my lord. My lord, may I take your page 55, my lord, on oath, my lord. The accused used to gaze his cattle near my field. Sorry, my lord, his cattle near my field. On the day of incidents, it was raining. So I asked the accused to cut some leaves, tokopata for me. Apart from that, I don't know nothing about this case. Police has recorded my statement. Cross, my lord. I cannot say the time, date, and year. The accused cut the leaves from my garden. My lord, testimony of this, my lord, PW 5 is that, my lord, on that day, my lord, he has seen the accused nearby the place of occurrence. That is only the testimony. Other than that, my lord, there is no any, my lord, whisper that he has seen the accused committing the, my lord, offense. And next is, my lord, PW 6, my lord.
Who is she?
She is, my lord, on that day, my lord, she was with PW 5, my lord. When this PW 5 asked the accused person to cut the tokopata, my lord. On oath, my lord, I know the accused standing on the dock. He is fresh. I don't remember the day, month, and year, but one day it was raining. While I was harvesting paddy, the accused was asked to cut leaves, tokopata by Baido. Baido is, my lord, PW 5, my lord. After covering the paddy, we left. From this also, my lord, there is nothing, my lord, as such, which can be, my lord, discernible that, my lord, this offense was committed by the accused, my lord. Thereafter, my lord, next, my lord, relevant witness, my lord, will be, my lord.
Who is 3 and 4?
Yes, my lord. 3 is, my lord,
Doctor.
Yes, my lord, who has conducted the postmortem. my lord.
Postmortem.
Yes, my lord.
And who is 4?
4 is, my lord, who has recorded the confessional statement of the accused, my lord. Confessional statement of the accused, my lord.
Okay, magistrate.
Yes, magistrate.
Yes. Okay.
My lord, if I take your lordship to do, my lord, the position of PW4, my lord, there's 54, my lord. My lord, on oath, my lord, I have recorded the confessional statement of the accused Suresh Maji. I have recorded whatever the accused stated before me, and I have explained him. PW8 is the statement of the accused, and which I have recorded, and exhibit 7A is my signature. In the cross, the accused has voluntarily given his statement. The IO has prayed for recording the statement. No police personnel were present at the time of recording the statement. It is not a fact that I have not followed the procedure for recording the confessional statement of the accused. I have been given enough reflection time to the accused. The accused was brought to me on 7/10/2016. My lord, in this case, my lord, no doubt there is no any, my lord, infirmity in my lord recording the procedure followed by the magistrate while recording the statement, my lord. My lord, only thing which I want to submit is that, my lord, well, this confessional statement, my lord, has been, my lord, retracted by the accused while examining him under section 313 of the CRPC, my lord. He was retracted his confession, my lord, in under section 313 report, my lord. Now, my lord, I was may I take your lordship to, my lord, 313, my lord, statement of the my lord accused person, page 60. Page 60. This is the, my lord, examination under section 313 of the CRPC, my lord. My lord, question number 3, my lord, the relevant, my lord. My lord, reported, my lord, question number 2, my lord, that PW3 deposed that he examined the deceased and found that weapon used in the offense is a dao. Do you have to say anything on this? He just replied, I have no idea. They have the question number 3, my lord. This is relevant, my lord. That the PW4 deposed that he recorded your confessional statement. Do you have to say anything on this? Answer, my lord. His explanation, my lord, which is relevant, my lord. I was badly tortured by the IO before I was sent to magistrate. And I was also threatened by the police to confess before the magistrate. So I don't remember what I have stated. Then question number 4, my lord, that the PW4, my lord, this magistrate, my lord, disposed that he give you reflection time. Do you have to say anything on this? Answer, my lord. It is true that I is given enough time for reflection, but the said magistrate, but I knew that if I don't admit and confess before the magistrate, then I would have been tortured again by the IO. Question number 5, my lord. Where were you sent back after recording your confessional statement? My lord, kindly, my lord, noted it, my lord. I was produced from the lockup where I was kept since my arrest and sent back to same lockup after having recorded my confessional statement. My lord, why I'm pointing out this, my lord? In my humble submission, my lord, the confession made by the accused, my lord, seems to be not voluntary, my lord. Why I'm saying so, my lord? In respect to question number 3, my lord, he says that he was badly tortured by the IO to confess. And question number, my lord, 5, where were you sent back after recording your confession statement? He said that I was produced from lockup where I was kept since my arrest and sent back to lockup after having recorded my confessional statement. Now, my lord, in my humble submission, if I, my lord, submit that, my lord, his confession is not voluntarily and it was retracted, my lord. If confession was retracted, my lord, then, my lord, it will be, my lord, or to base that confession as a basis for conviction, my lord, prosecution was, my lord, court. I'm sorry, my court has to go to other witnesses, other evidences, material evidences. For that, my lord, first, my lord, since my lord, recovery of down, which is alleged to be a murder weapon, this was recovered from the house of the my lord, room of the my lord, accused person. My lord, that recovery has to be proved, my lord, beyond reasonable doubt. It has to be conclusively proved, my lord, that that weapon has been recovered from the room of the accused person. For that, my lord, may I take your lordship to my lord that Caesar list again, my lord, which is at page 25, my lord. Page 25, my lord. Name of Caesar witness, my lord.
Page 25.
Yes, my lord. My lord, it's the rule of procedure, my lord. When something is been seized, my lord, there should be an independent witness, my lord, accompanied with the seizure, my lord, authority, my lord. Seizing authority. My lord, may I take your lordship the name of Caesar witness, my lord? One, Sri Barna Kadia. Two, Sri Nicholas Kadia. My lord, one is the complainant, and two is the father of
Complaint.
victim, my lord. This is the
Same.
same.
Complaint.
Oh, yes, yes.
Informant is the brother.
My lord, they are, my lord, they cannot be said to be an independent witness, my lord. And next two, my lord, Bosco Purti and Manuel Jotorama, my lord, they are independent witnesses. But they are, my lord, their my lord, testimony is not being taken by the land. Their testimony, my lord, their evidence. Yes, this Bosco Purti and Manuel Jotorama, my lord, they are not before the court
Okay.
to testify their testimony, my lord. Had they had been, my lord, it will be conclusively proved that thou has been seized from the room of the accused person. Now, next, my lord, it is the case of the prosecution. In the thou, my lord, some blood stain, my lord, has been found, my lord. For that, my lord, they have sent it to FSL, my lord, for obtaining FSL report for forensic, my lord. And my lord, FSL report, my lord, is page 33, my lord. I have already shown to you, my lord. Even then, my lord, may I again take your lordship to FSL, my lord, page 33. Relevant is at page 35. My lord, may kindly note, madam, two exhibits are some exhibit A and exhibit B. And exhibit A is thou, and exhibit B is the, my lord, blood sample of the deceased man. Now, as per this, my lord, report, my lord, result of the examination, which is, my lord, 13, my lord, para 13, my lord, down below, my lord, on the basis of above examination, it is concluded that human blood could be detected in exhibit A. The blood group could not be detected in exhibit A, hence it cannot be compared with exhibit B.
From where do you say this exhibit B was the blood sample of the
Yes, my lord.
accused? Sorry, the disease.
This is one. My lord, yeah, that can be, my lord, found from, my lord, evidence of, my lord, the position of PW7, man, 7.
Oh, that is okay. Breakfast is going to be short and good. Student handle. Oh, this is not a good review. Huh? Oh, this is a good review. Okay, breakfast is going to be short and good. But something or the other, I think, but I think that the words. How you do it? Yes.
Yes, ma'am. My lord, page 57, my lord, the deposition of my lord, IO investigation officer, my lord.
Now, why it was not open? Exhibit B was?
Because my lord, because my lord, though my lord, human blood could be it was detected in my lord exhibit B, my lord, but blood group, my lord, cannot be my lord ascertained. Therefore, they have not, my lord.
No, just a moment. Here, one sealed covered
Wooden box
Box.
containing exhibit mark A and B. Exhibit A,
A and B.
now,
Exhibit A is thou.
yes.
What is B?
Exhibit B was not open in the laboratory.
No,
The exhibit B is the my lord, blood sample of disease. My lord.
blood sample of disease.
Yes, my lord.
Where it is written?
My lord, that can be found on my lord, evidence of PW7, my lord, page 57, my lord. Page 57, my lord,
57. Who
is the IO, my lord, investigation officer of this case, my lord. My lord, from
blood sample was taken from the disease.
disease, my lord.
Okay. Yes.
My lord, from down, my lord, line 1, 2, 3, 4, 5. If the seize down of the accused was marked as exhibit A. From down, my lord, line 5. The seize down of accused was marked as exhibit A, and blood stain of deceased girl marked as exhibit B.
Okay.
And both exhibits were forwarded to CFS cell Guwahati through the JMFC Mahadevpur.
Hmm.
Now, my lord, in my humble submission, my lord, first, my lord, though my lord, it can be said, my lord, human blood was detected in my lord that. Now, but my lord, it is not conclusive proof that that blood stain is of deceased person. My lord.
But what is the explanation for the accused side? He remains silent. That cow is under the recovered from his house.
Yes, my lord.
Human blood stain.
Yes, ma'am.
That is there. And regarding the seizure witnesses, they were also present at the time of seizure. They were not cross-examined on that part. That regarded whether you were present or not. That part is silent.
Yes, ma'am.
The dove is recovered from the top of the house. That is also there. He remains silent regarding the blood stain. Is there any explanation from his side that whether the blood group, also blood stain whether was there in the?
My lord,
I don't think there is any explanation.
my lord, if we go
Even
to
in 330 statement also,
339,
is there any?
60. My lord, I think, my lord, that poison has not been posed to the accused, my lord. During the examination, my lord. Question number 2, my lord, only says that PW3 reports that he examined the disease and found that weapon used in the offense is a dao. do you have to say anything on this? He said, I have no idea. My lord, that question was not, my lord, asked to the
But
accused
he
person.
was
but-
most probably given the opportunity in the question number 11 to elaborately say if there was anything regarding.
My lord, that is the amount. But even then, my lord, as per my lord, as per my lord, law laid down by my lord, our honorable, a specific question should be asked. My lord. If my lord recovery is there and there is partition, that has to be asked and let him explain such question. That has to be done. That has not been done. And regarding my lord, this my lord, report, my lord, in my humble submission, my lord, in such a circumstance, my lord, the person who has my lord, made the report, my lord, who has conducted the FSL, my lord, he ought to have been my lord, someone to give or his or her testimony. My lord. Why such thing has been happened? There might be some my lord, scientific reason. Had that explanation with here, my lord, the case would have been on other direction. That's why I'm pointing out this. Page 33, my lord, CFO's report, my lord. And page 33, my lord, if your lordship take to page, there is, my lord, specifically, my lord, communicated by the this my lord, who has conducted the CFL report, my lord, who has made this CFL report. There. Page 33, my lord, down below, my lord. He said if evidence is required, correspondence may be made to
Where?
may please to be made. My lord, page 33, my lord. When this my lord report has been forwarded to the my lord, judicial magistrate. Second one. My lord, the second para, if evidence is required, correspondence may be please be made with Sri S.K. Malik, scientist B biology of CFS body, who is authorized examiner and reporting officer in this case. Quoting CFSL forensic examination report number and that period.
So the report was exhibited by whom? No one.
Not exhibited.
It's not
This not exhibited, but because this person was only this was exhibited by prosecution, my lord. IO has exhibited this report.
I was
Exhibited, my lord. Not by him. My lord, in such a circumstances, my lord, in my humble submission, my lord, is that my lord. My lord, the conviction can be based on my retracted confession, my lord, that can be based. But my lord, it is rule of prudence. My lord, before basing this such conviction, my lord, the court has to go to other material evidences, my lord, whether it is corroborate or not. If my lord, there is corroboration, my lord, conviction can be made basing on my lord, retracted confession also. My lord, I have given this, my lord, this Ramananda painting for this state of person, just hand over to him. And my lord, if your lordship like to my lord, peruse the judgment of the order, my lord, reason and my lord, decision of the session judge, my lord, it can be found on my lord, page 74, my lord, onward. And although my lord, in this his my lord, reason and decision, my lord, all this thing has been taken into consideration. Thereafter, my lord, he has convicted the present applicant, my lord. Only one thing I have to point out, my lord, in this case, my lord. The conviction was based on hypothesis only, my lord. He could have. Well, there is no any conclusive affirmation by the landed assistant judgment. May I take your seat to my lord, page 74, my lord. Discussion, reason and decision of the assistant judgment, page 74. On the Bible. Page 74. Paragraph 15. Paragraph 15 is the fact, my lord. In the manner, I have to read it out, my lord. The PW1, after having searched the missing sister, has finally located her dead body inside the Topopata garden, lying on the ground with multiple cut injuries. He accordingly has lodged the FIR against the unknown person. The IO, having received a fire against unknown person, started his investigation, and during the investigation, he made a search in the house of the accused person and recovered a weapon of the person that contained blood stain. He thereafter has arrested the accused person. The blood stain found on the said weapon of offense was sent to FSL, and accordingly, IO has confirmed that said blood to be a blood of human, though the same could not be matched with the blood of God. This court has perused the deposition of PW5 and 6, who are near. Who are those two ladies who saw the accused person near the PO, who is a which is a Tokopat garden located near the paddy field on the day of incident. This court, from the deposition of PW5 and 6, is convinced that the accused was seen on the day of the incident at PO, and this has been settled. This has not been settled by the defense counsel at cross-examination. Thus, this court believes that the accused was present at the PO on the day of incident. My lord, that cannot be disputed. He was, my lord, there at PO at the time of incident. The finding thereafter, my lord, the finding of the human blood on the weapon of offense said to have been seized is for exhibit P Expo by the IO has strengthened the opinion of the court to make a conclusion that it is the accused who has killed the deceased. The court makes it clear that the said dog has been seized in presence of prosecution witness 1, prosecution witness 2, who have put their signature on the said seizure memo as a seal. It is also seen that this PW1 and 2 have identified the said dog seized before him by IO. Herein, this court and the said dog is exhibited at such and such. The seizure memo and the deposition of this seizure witnesses have nowhere been damaged by the defense counsel, as the defense counsel is found to have declined to prosecute this. That effort, the medical report said that the weapon of the offense said to have been used must be a sharp weapon like dagger. The IO has specifically stated that he has collected the blood stain from the said dagger and has marked it as Exhibit A, and the same was sent to FSL. But this fact neither has been disputed nor damaged by the defense counsel during the cross-examination. It has therefore convinced this court that the accused from whom the weapon of offense has been seized, where human blood is detected, must be one who has killed the safeguard. The deposition of PW, who is a magistrate, has made it clear that the accused has made a confessional statement voluntary, and his deposition made it clear that the said accused could have not been produced from police custody. This is because the magistrate who is examined as PW4 has deposed that the accused was produced before him on 7/10/2016, and on perusal of said confessional statement, the accused has been produced before him on 7/10/2016. The accused is found to have stated that he was arrested on such and such. On the perusal of FIR has been goes missing on otherwise recovered on such and such. On perusal of charge sheet is revealed that unknown accused is traced out on such and such. Thus, I believe that the accused is arrested on such and such. If this is so, then accused who has been produced before the magistrate on 7 would have been, my lord, all our hypotheses would have been produced from, my lord, police, not from the police custody, but had been produced from judicial custody, my lord. All our hypotheses, man. If I go, my lord, all through this judgment. It's what might given on hypothesis only. There is no any concrete matter, conclusive, my lord, there is lack of conclusiveness. My lord. I will not borrow much to your lordship, pardon, my lord. I will, my lord, conclude my submission with this man. Oblige.
Why was this man arrested by the police?
Lordship, FI Lordship and Lordship, FI Lordship had been lodged by the victim's brother. And during the investigation, Lordship, that accused has been Lordship, arrested Lordship.
No, that's what I'm asking.
Lordship,
Why was he arrested?
Lordship, because
On
Lordship,
there must be some basis for the IO to arrest anybody
Lordship,
on suspect,
Lordship.
is not it?
Lordship here also, Lordship, in the statement of the Lordship, what?
We'll hear you tomorrow. Okay. Any idea why was the IO, why did the IO suspected this person?
Lordship, during investigation, Lordship, their Lordship, their family, they told that they have, their sister and their daughter have some.
Had some relationship.
Lordship,
Who told this to the IO?
Lordship,
I
during.
don't find in the statement of her brother or the father, who told that there was some kind of relationship between the disease and the.
And Lordship, here statement also 164 also, that guy also, he confessed.
No, 164 is letter.
Lordship.
I was
So,
just trying to find out.
The 161 is not here, Lordship, in this paper book, Lordship.
Okay. Well, could be. Have you gone through that?
Lordship, because 164 only here in paper book, 161, that statement is not in, attached in this paper book.
Somebody may have told.
Lordship, yes, Lordship, during investigation, Lordship.
All right, we'll hear it tomorrow.
Lordship.
Yes, it tomorrow.
Lâu chỉ là cái mình.
Yes, madam, I beg to mention item 24, madam. Madam, this was kindly taken up on Wednesday, madam. Item 24, madam. I requested Mr. Tapin also, madam. On Wednesday.
What is the matter, madam?
Madam, this is regarding my non-payment of pensionary benefits, madam.
Pensionary benefit. On account of what?
Madam?
On account of what?
On account of, my lord, in fact, my lord, the petitioners, my lord, despite the order of this honorable court, my lord, his service has been not been regularized, my lord. Thereafter, after a long time, my lord, his service has been regularized, my lord. By that time, my lord, new pension scheme has come on. That's why, my lord, the state is saying that, my lord, the new pension is applicable to me, my lord, not the earlier pension scheme, my lord.
On Wednesday,
On Wednesday,
not on any other day. Maybe next week, something like, no.
my lord.
Huh? So after a week,
My lord.
on the prayer of Mr. Saike. Official listed after a week.
Okay.
My lord, I beg to mention item number 23, my lord, on behalf of El Sultana, my lord. Due to some personal difficulties, my lord, they are not able to come today, my lord.
Item number
23.
23. What is the matter about?
my lord, I don't have record, my lord, since the petitioner are from the Guwahati, my lord.
Then you will have to wait. Let us see what is the matter about. Matter may have become
My lord, I
interesting.
have taken the consent from respondent also.
We don't know whether anything survives to be adjudicated or not. This is how many years old writ petition? Do you have any idea?
No, my lord.
So let us have some idea together. When the matter is called up, you also go through the record.
My lord, I don't have the record, my lord, I record in.
You
the
take
court.
the record from the court. Okay,
Yes,
then
my
find out what is what. Yes,
Yeah, my lord, I beg to mention item number 6.
yes.
I've taken consent from the opposite council, my lord. This matter will fix after 3 weeks.
What is the matter about?
It's about regularization of the petitioners.
Regularization of service.
Yes, my lord.
In which post?
Casual labor for regularizing.
Affidavits have been filed.
Yes, my lord.
On the prayer of Mr. T. Tagu, Learned Counsel for the petitioners, listed after 6 weeks.
Much obliged.
Your Lordship, I would like to mention item number 16.
Yes.
Council, he couldn't turn up today, my lord, due to health issues.
What is the matter about?
My lord, I don't have the idea of the matter. I've been just instructed to seek
Where is
confirmation.
Kapi Omo?
Yes,
You are making mention for whom? Nibo?
from N Nebo. Yes, I'm Nebo.
Yeah, what is the matter about Omo?
I thought in this case, the petitioner has challenged the appointment of the director and the creation of the department of ULB. Meetings already completed.
Okay, all right.
My lord, my humble request, the matter may be fixed for this coming the 27th of this month.
Not necessary, not possible. You had Mr. Your name?
My name is M. Kambo.
M.
Kambo.
Kambo. M for
Michi Kambo.
Learned Counsel on behalf of Mr. M. Nivo, Learned Counsel for the petitioner, who prays for the adjournment of the case. Mr. Omo, Learned Standing Counsel for ULB, has submitted a counter affidavit by the respondents have been filed. Was in view of the listed up to 6 weeks for admission hearing. Okay.
I'm representing the director, only director.
Only the director.
Yes. And the state respondent represented the council.
Okay. Any private respondent?
There is one private respondent, but.
Notice has been served.
Last occasion, the service was not completed.
This is the difficulty. You have to, you please wait. Wait, let us see the record. What for it is listed today? Okay, see. You have to see, you have to know what is to be submitted at the admission stage, motion stage, admission stage, order stage. You must have some idea. And what the court is required to pass order in each of the stages. So wait. You want to go anywhere? In the meantime, you may check the record also. For the whoever would like to check the records would be made available by the staff of the registry to your respective. Okay. If anybody is interested to have a look at what is what, record will be provided. Okay. So you wait. Yes. Anybody else would like to mention?
May I please, Lordship? Lordship, I would like.
You have heard what we have
Yes.
discussed?
Yes.
Okay.
Your Lordship, I would like to mention item number 10.
Item number 10.
This is regarding service matter. And I've taken consent from other political.
What is the matter about?
The service.
Then you have to wait. Service is a very broad concept, broad subject. You have to wait. You may also find out what kind of a service method is this?
May my lord, I beg to mention item number 18.
18,
Yes,
yes.
my lord, the council in this case, Mr. T Talang is out of station.
Who is out of station?
Mr. T Talang,
Ah,
so it may be listed after two.
what for? What is the
Lordship,
matter about?
I'm appearing for respondent number 3.
Yes,
I have filed one IE in this case for praying for filing additional affidavit, Your Honor.
just a moment. What is the matter about?
It's tender matter
Tender matter. What for it has been listed today?
order.
Orders. Then you have to wait to find out what kind of orders.
Yeah, my lord, in fact, all our clearings are basically complete, my lord.
Readings are complete.
Yes, ma'am.
Yes, Lordship. I have filed an
We have,
IE, Your Lordship.
I'm appearing for the respondent number 4, my lord. And here respondent number 5 is
Just
yet to
a moment.
appear.
You are for R4.
Yes, ma'am.
You are for?
I'm for R3, Your Lordship. I have filed an IE 108 of
No,
2023.
Just R3. Both of you have filed your.
Yes, we have filed my account of it. However,
Okay.
I
Just-
have
just-
filed.
Just RTI application you have filed elsewhere.
No,
Not
Your
here.
Lordship. I have filed another IE seeking leave of the court to file an additional affidavit, Your Lordship.
It is listed today.
Yes, Your Lordship.
IA, my
108.
lord, that IA 108, they have filed an IA seeking leave to file additional affidavit, my lord.
Okay. Then let the matter be called up. Government has also filed
Yes.
affidavit.
Not yet, Mr. Our
Okay.
affidavit is ready, but.
Okay. Then Miss, you have to wait, Miss.
Okay.
Yes.
May I please, my lord? I beg to mention item number 7,
7,
on behalf of Opada,
on behalf of,
Opada,
huh?
Opada,
Oh, father, yes.
a landed council is out of station.
What is the matter about?
This matter is about, the retirement.
Retirement?
Yeah, but, actually petitioner, my lord, petitioner is about to retirement.
Hmm.
So, he has applied NOC.
Okay, father is representing the vigilance.
Yeah, the
Vigilance.
respondent- that's one.
7, yes, 7.
Yes, my lord.
That for what, encroachment? How many more matters you have such kind of matter?
Pending now.
Pending. Where is T Wangmo?
Similar matters have already done stuff.
T Wangmo was request,
She's absent today.
see, that the T Wangmo was requested to give a list of case. Where the non-payment of the pension on the ground of the NOC is pending before this court. He was given 1 week time. Then he came back after a week and said there are only 2 matters pending. And that one matter which had come up on that day, we have already disposed of. So according to the statistics given by Wangmo, there should be only one writ petition, one such writ petition should be pending.
This is the
So-
one which was given that day. Also.
Now, see,
I withdrew the similar matter only the 3-4 days that was compiled.
okay, then this is one more matter.
This is the matter which was referred that day.
Oh,
This
that
is
day.
pending.
You have any other matter?
But you know, very-
Have you checked out?
Lordship, so far this case is concerned of this particular case.
Ah,
This case, it was brought before this one could that day, Lordship,
okay.
by T. Wangmo, Lordship. So far rest cases are concerned, Lordship. It's sometimes very difficult to sort out, Lordship, the cases which are pending before this one.
No, see, all the case filed against the government is with you,
Correct, Lordship.
isn't it?
Lordship.
Promotion matter, and seniority matter, pension matter. Pension matter also there will be various kinds of. Now you have to sort it out. You have to find it out.
Because the way the files are being kept, Lordship.
No,
because
see, that is your lookout. That is your
correct,
lookout.
Lordship.
In whatever manner you keep your file. But if you make some effort, you can always find out. We can't ask the private lawyers to some has one and some has two, but you have entire records with you. Can you do that exercise? So that see, we are passing in a piecemeal order. All this repetition can be disposed of by single order. NOC, for NOC, you can't deny pension. So why don't you do the exercise?
Lordship, I'll ask the staffs to sort it out, Lordship. Because we are also dependent on the Lordship, our staff only. Lordship.
Oh,
They what happened, Lordship? Mr. Wang, I mean, Wang Mo, Lordship.
this exercise is being done in the principal seat and elsewhere in the country. So that entire matter is taken up in one go and pass a common order, so that the maximum relief is got by the maximum of the petitioners. Here, after 1 week, we are passing one order. And it will be same order.
Lordship, we'll do that.
I think. What is your prayer?
So my lord.
Okay, we'll take it up after a week. I think within a week, you will be able to do it.
Lordship,
Within a week, you will be able to do it.
how within a week?
We'll list it on Monday. Today is Monday, huh? Next Monday, we'll list it. And by that time, you try to find out.
We'll try best to find out.
From your submission, it appears that
Lordship.
Wangmo has not done the exercise. What was within her knowledge, he has given to us. She has given to us. Ask her. List is on Monday, okay?
Monday.
31st.
My lord, matter may be listed after 2 weeks.
We'll see on that day. Item 7. 31st.
Hello, I am making mention of item
Just a moment.
on behalf of Kagum.
Just a moment. You're in item number 7. An adjournment is sought for on behalf of Mr. Opada, Learned Council. Mr. D. Pangi, Learned Council, for the petitioner submits that matter pertains to non-payment of pension to the petitioner on the ground that no objection certificate regarding non-encroachment of the public premises has not been submitted by the petitioner. Mr. Tapin, Learned Senior Government Advocate, is requested to submit the list of such pending such cases pending adjudication by the court by 31st of July. List it on 31st of July.
Hello, I am making mention of item number 25 on behalf of Kagum Jamu Student Council Education.
T. Jamu?
Yes.
Yes. What is this matter about? What is this matter about?
Lordship, I don't know. In fact, Lordship,
25.
I'm told that yes, I'm told that he has
Mr.
obtained the consent of the other.
Pangil appears to be here. What kind of, what matter is this? 25?
25, I'm told that Senior Advocate Ajingu Parada, Ajingapag is appearing.
Yes, on you. What kind you are no longer there. What kind of matter is this?
The petition was terminated. Yes, this is regarding termination.
From which post?
From she was serving as
Assistant teacher.
yes.
Regular teacher.
Lordship, normally teachers are not regular.
Okay.
So he was terminated and on the allegation that there was paper leakage. And inquiry report is reported on the report. And there is also a police case. So that is there. So now today, he was supposed to come with a record. So specifically, we have asked for a record of issuing so cause notice to us before termination. Also, in their affidavit, they have said that instructions were given not to take out unused question papers after examination. So these two records were called for. Now, as per our RTI application, there is no such record. But since they have stated in the affidavit, we have asked for. So he couldn't obtain that record personally from Congress. He requested me today in the morning, saying that another 1 week may be given. So I have considered for 1 week.
Okay.
In fact, he has instructed me to get the matter fixed on 3rd of August. 3rd of August.
As per his request, only 1 week.
1 week.
He was here in the morning.
Yes,
Because of his health, he was.
since he was not feeling well. So he-
3rd of August is little more than a week only. We'll fix it on 3rd of August. Okay.
Much obliged.
That is his prayer.
Yes, that is his prayer.
All right, on the prayer made by D. Kamdu, Government Council on behalf of Mr. T. Jama, Extending Council Education Department with the consent of Mr. A. Appa, and Senate Council for the petition listed on 3rd of August. Okay. Number 1.
May it please your lordship.
Yes.
Lordship, here, this verification, I have essayed the impugn result notification dated 7/7/2023, whereby the petitioner's firm's technical bit has petitioner firm has been disqualified. Now, lordship, the fact of the case is that the petitioner has participated in NIT dated 23rd/6/2023 for the work care of type 4 water number 1 at Bolen with an estimated cost of 57 lakhs 41,000. Now, what has happened, lordship? Now, the technical bid for the same was opened on 4/7/2023, and thereafter the petitioner firm has been disqualified. Lordship, the impugn result notification is at page 119.
119,
119.
yes.
And the petitioner firm is at serial number 15, lordship. Just
15.
Yes, 15, page 121.
Yes.
Petitioner firm is Messrs. Hilbert Infra, which is
Philberg.
Infra, which is reflected in number
Yes.
4 farm.
Yes.
So basically, I'm concerned with the serial number 15 disqualification. Now, thereafter, since this result notification was the petitioner came to know regarding this result notification. Thereafter, the petitioner has approached the respondent authority to representation dated 10/7/2023.
No, you have been disqualified on what ground?
Yes, lordship, I'm coming to that, lordship. Now, the basic.
The ground has not been given in this notification, page 119.
Yes, yes, here it is not given.
Okay.
Now, after submission of my representation, which is at page 123, basically I was the petitioner has requested for consideration of a reconsideration of the result notification and to consider the technical bit of the petitioner. Now, thereafter, the respondent authority has issued the reply dated 11/7/2023. May I take your lordship to page 125?
Yes.
May I read, lordship?
Yes.
Reply to disqualification of technical bid against so and so at Bolang so and so. With reference to your letter dated so and so regarding disqualification of technical bid against the work care of type 4 quarter number 1 at the Bolang by the bid evaluation committee. This office has gone through your complaint for disqualification in technical bid thoroughly and found that your documents have not fulfilled the technical compliance at serial number 20 and no affidavit number in all stamp papers submitted by the firm. So this was the reply given by the competent authority.
Serial number 20 has not been complied with, huh?
Yes, Lordship. And another ground, no affidavit number in all stamp papers. Now, with regards to that, Lordship, I have submitted a on the same day, I have submitted representation, which is at page 126.
What is serial number 20?
Serial number 20, may I take your Lordship to page 42 of my writ petition? 42, Lordship.
Yes,
42, Lordship, serial number 20, may I read, Lordship?
yes.
Total amount of experience in building construction for last 5 years, other than maintenance work certified by the authority competent to issue work order or accept tender.
Ah.
So with down below, Lordship, serial number 20.
Yes.
Basically, it talks about experience certificate, works experience certificate. Now, with regards to that, Lordship, I have submitted this representation dated 120, representation dated 11/7/2023, which is at page 126, annexure 5.
Yes.
So, Lordship, in fact, here I have requested for opening of my price bid, Lordship.
Did you submit experience certificate?
No, Lordship.
You are
Yes,
not.
I'll be coming to that.
Okay.
Now, may I read this, Lordship?
Yes.
With reference to subject cited above, it is to inform your esteemed authority that technical compliance at serial number 20 talks about requirement for producing proof of completion of work of similar type. And in this regard, it is to apprise your good self that the submission of the same is exempted for class 4 and class 5 registered contractors as per the provisions of Rule 2D of Arunachal Pradesh District-Based Entrepreneurs and Professional Rules 2005. Further, with regards to the affidavit number in all stamp paper, the affidavit of the undersigned firm has been duly executed before the competent authority. Moreover, other firms, namely the private respondent here in this writ petition, Lordship, have.
All right.
Yes. So my
experience is exempted.
Yes.
Experience is exempted
under Rule 4, Lordship. Rule 4(2)D of Arunachal District-Based Entrepreneurship.
Affidavit you had submitted.
Yes, affidavit I have submitted. Now the respondent authority has disqualified me only on these two grounds. Number one, that no experience certificate as per technical compliance is serial number 2. And number 2, no affidavit. Now, with regards to technical, with regards to work experience certificate, Lordship, may I take Lordship to page 144 of my writ petition, Lordship.
If it is exempted, you are not required to submit.
Yes, Lordship. However, I have been disqualified on this very ground, Lordship, that I have not complied the technical compliance given under serial number 20 as per their reply, Lordship.
Okay, yes.
And then with regards to that numbering of affidavit, Lordship, that during the examination of technical bid documents, it was found that all the participating firms, including the petitioner as well as the private respondents, none of them had numbered their affidavit in stamp paper. However, since there was no objection from either of the side, I mean,
affidavit is to be numbered.
Yes, that grounds they have given, but however,
where in the NIT it has been provided?
there is no provision, Lordship. There is no clause citing that affidavit has to be numbered. So,
but affidavit has to be submitted.
Yes, Lordship, that I have submitted. Lordship.
Which is that clause in the NIT?
NIT, Lordship,
affidavit part?
Affidavit part is at Lordship 16, serial number 16, page 42, Lordship.
Page
42.
Serial number 16.
Yes, Lordship.
Okay.
May I read, Lordship?
Self-declaration affidavit
number.
Number
that no 3 works are in progress at anywhere under government of Arunachal Pradesh as per format and closing tender paper.
What is this number? Affidavit number?
Self-declaration affidavit, Lordship, this basically talks about affidavit.
What is this number or date? There's no
Self-
words are in provision. Okay, all right.
So only on these two grounds, however, Lordship, may I take Lordship to page 144.
But from page 42, serial number 16, there appears to be, there has to be some number in the affidavit.
Lordship, with regards to that, these private respondent, these two private respondents, their affidavit were also not numbered during the examination.
Where is your affidavit?
Lordship,
Have
this
you
this
annexed?
particular affidavit,
Yes,
Lordship, that we have already submitted before.
you don't have a Xerox copy.
No, Lordship.
Affidavit was executed before whom?
Executed before the concerned executive magistrate, Lordship.
Okay. Yes,
And with regards to this, Lordship, with regards to the exemption, that is very clear in
page number.
page number 144, Lordship. Type copy of the Arunachal Pradesh District Press Entrepreneurs Rules 2015.
Yes,
144, Lordship.
yes.
D, Lordship.
Hmm.
The categories 4 and 5 contractors shall be exempted from requirements for producing proof of completion of work.
Just a moment. Page 144,
Yes, Lordship.
which
D, Lordship, D. Rule 4,
in page
sub rule 2, D.
is 144.
Yes, Lordship.
In 144, I have this series of column, serial number 2, 3, 4, 5, 6.
Lordship, 145, Lordship.
145, yes.
D, Lordship. D.
D means
Rule 4, sub rule 2, D.
rule 4 is at 143.
Yes.
Rule 4 starts from 142.
Yes.
Method
Methods and
and
procedures.
procedures are 142. And next page 43, you are referring to clause D.
Yes, Lordship.
Yes, categories 4 and 5.
Yes, the categories 4 and 5 contractors shall be exempted from requirements for producing proof of completion of works similar type in last 5 years to qualify for participation in a tender.
You are which category?
A class 4, Lordship.
Okay.
And with regards to that affidavit number, Lordship, that they have already accepted the technical bits of the private respondent.
Okay.
So their affidavit were also not numbered. To that aspect, I have made a specific amendment in my report.
How many respondents?
2 respondents.
Private respondents. There are 2 private respondents.
Yes, Lordship. So my prayer is, Lordship, let my price will be open, Lordship. If I'm qualified, then they will accept my price bid.
Where is the NIT?
NIT is at page 32, Lordship.
32. Okay. Yes, Tapin.
Lordship, firstly, Lordship, so far this experience certificate is concerned, Lordship. Apparently, Lordship, so far act is concerned that exemption has been made, Lordship. But in NIT, that condition has been put in. And that knowingly, Lordship, the petitioner has participated. The act,
No,
Lordship,
your NIT can't override the act.
Lordship, that is there, that is Lordship as true. And so far, Lordship, the second ground of rejection is concerned, Lordship. This, Lordship, I asked from the authority, the affidavit filed by the petitioner, Lordship, submitted by the petitioner, and one of the Lordship, the bidder, Lordship. So far, number is concerned, Lordship. After the affidavit is executed, Lordship, the concerned office used to maintain a register, Lordship, where this registration is done, Lordship. And thereafter, Lordship, number is given, Lordship. I think I have given the other one also, Lordship.
Other, yes.
On top, Lordship, you
KD.
find the serial number, Lordship. And the date lawsuit is the date of registration number along with the date lawsuit. But in case of the petitioner lawsuit, that registration has not been done lawsuit before the magistrate concerned lawsuit. So this is the one lawsuit ground on which lawsuit, because in NIT it specifically mentioned lawsuit in condition number 16 lawsuit.
This is, this affidavit is regarding what? Self-declaration of that there is no work pending.
Lawsuit. And apart from the lawsuit, that lawsuit, if lawsuit, read the lawsuit, affidavit itself lawsuit. The content is their lawsuit.
Yes.
It says lawsuit, there's no work more than lawsuit 3. Then third column lawsuit.
Just a moment. There appears to be one more respondent. There appears to be another bidder.
Another video.
Yes, Lordship. This is what KD.
KD.
And who is the other one?
So KD is not the private respondent here, Lord.
KD is not the private respondent.
It seems
Present
KD
respondents
is
are Arunachal traders and
KD is not here, Lord.
continental traders. Lordship.
Then who is this KD?
KD is one of the participants. Since
His technical video has been cleared.
it's not clear,
KD
it seems, Lord.
Just a moment. You get.
Kindly see the lawsuit technical date result.
Just a moment. Do you have the affidavit of this Arunachal traders and continental?
No, just
traders?
for example, I have furnished no rest
No.
affidavit I have not received.
All right. Then what do we do? This appears to be a negligible one. You want to take instruction on this, because his case is that this respondent number 7 and 8 affidavit is also not numbered.
Lawsuit, may I lawsuit, it may be taken after some time lawsuit. So I'll ask for the affidavit filed by the private respondent lawsuit, who have been lawsuit technically qualified. Just after some time lawsuit, through WhatsApp. Because amendment has been made in the writ petition lawsuit, as my friend has
Yes,
referred.
I have met.
After some time.
After some time.
And Lordship, another aspect, Lordship, which these particular private respondents, they were not represented by authorized representative also during the opening of the technical. Neither the proprietor nor the authorized representative was there.
In what? East Siang district, this affidavit.
Siang district, we are particular.
No, affidavit is not numbered or what?
Lordship, they have given registration number. However, that number, with regards to that number, of course, I concede that that has not been numbered, but the executing authority, they used to register, they used to give certain numbers.
Because that number is at least for the limited purpose.
Yes, Lord.
That you have executed this affidavit before that authority.
Yes, Lord. So that, with regards to that, even the private respondent, they have not numbered their affidavit. Lord.
Okay. If they have numbered, then your case will go.
Lordship, yes, Lordship.
Okay, then let him. Okay.
Here, the petitioner matter is challenging the matter appointment of respondent number 6 as a minor chairman of the Arunachal Pradesh Public Service Commission, and secondly, the advertisement dated matter 24/4/2023 is being put to challenge before this honorable court matter. Under the petitioner matter, by due selection process to a constitutional post, was appointed as a member of Arunachal Public Service Commission on 6/1/2017 matter. And matter he is discharged till 5 years and 9 months matter as a member Arunachal Pradesh Public Service Commission. My lord, due to the fiasco, APCS fiasco matter, and the further steps taken by the government matter, saying that my lord, the matters were referred for presidential reference, and which was my lord published in all social media, electronic media, and print media, my lord. Succumb to that, my lord, the chairperson, the erstwhile chairperson of Arunachal Pradesh Public Service Commission, and many others resigned, my lord. As because the statements were coming forth in all the media, my lord. Then, my lord, the state has, my lord, referred for presidential reference for removal of the members, my lord, including chairman, my lord. So, my lord, the petitioner was the last person to, my lord, resign, my lord. And before, my lord, resignation of all the members, my lord, they took a resolution, my lord, that petitioner will look after the, my lord, the as a, my lord, chairman of Public Service Commission, my lord. Thereafter, on pressure built on me also, my lord. Subsequently, my lord, I also resigned, my lord. And one my lord, member who has not resigned, I have handed over the charge to her, my lord. Pursuant to that, my lord, fiasco, my lord, and the government has reconsidered everything, my lord, and made an advertisement on, my lord, 21/11/2022 for, my lord, the filling up of the vacant post of the chairman and 3 other members, my lord. That was, my lord, issued on 21/11/2022, my lord. My lord, kindly peruse for a moment, my lord, the advertisement at page 63, my lord. 63 is the, my lord, and also will come to page 65. My lord, before I laid this, my lord, advertisement to your lordship, my lord,
21st November.
21st November, my lord.
Yes.
In the state of Arunachal Pradesh, my lord, in terms of the, my lord, direction made by the Supreme Court, in, my lord, Salil Sablok versus, my lord, state of Punjab, my lord, the state of Arunachal Pradesh doesn't have any memorandum of procedure, my lord, or, my lord, methodology for selection of the chairman and the, my lord, members. Those are, my lord, constitutional posts, my lord. My lord, but, my lord, in the advertisement, they have given some criteria, my lord. At page 65, my lord. They, my lord, may I read, my lord? The advertisement, the government of Arunachal Pradesh is pleased to invite applications from the citizens of India for filling up the following vacancies in the Arunachal Pradesh Public Service Commission in terms of Article 316 of the Constitution of India. Chairman 1 post, member FPCSA 3 numbers, my lord. Eligibility criteria, my lord. Kindly see, my lord. Persons with outstanding career, basically it means, my lord, academic career, my lord. Outstanding academic excellence and capacity to judge independently suitability of the candidates for a civil post service under the government of Arunachal Pradesh. She shall not be member of parliament or member of legislative of any state or union territory or hold any other.
Here you applied for chairman.
Chairman, my lord.
You are not selected.
I am not selected, my lord.
Somebody else was selected.
Yes, my lord.
Okay, then what
My
happened?
lord, before the selection also, my lord, before the, my lord, the notification of, my lord, selected chairperson was issued, my lord. I have made representations, my lord, to the, my lord, authority, my lord, the state government, my lord, to follow the minimum, my lord, procedure, my lord. Why?
Did you challenge this advertisement?
No, my lord.
Okay, chapter ends there. Let us move ahead.
My lord. Thereafter, my lord.
You can challenge now. Yes.
My lord, my lord.
Yes.
Thereafter, my lord. My lord, a screening committee was constituted, my lord, for selecting this, my lord, candidatures, my lord. Lords, you will find at page, my lord, 74, my lord. The initial constitution of the screening committee, my lord. 74, my lord.
Yes.
One, my lord, Deepak Gupta, retired chairman, UPSC, Chief Secretary, Government of Arunachal Pradesh, Vice Chancellor, Nehu, Shillong, my lord. It was, my lord, certainly changed, my lord will find at page 75, my lord. My lord, because of, I will come to that, my lord, because of some ill health, my lord, the retired chairman of the UPC could not come. So they have, my lord, selected one, my lord, Ramesh Negi, IS retired, my lord. He was, my lord, in fact, my lord, at one point of time, he was Chief Secretary of the State of Arunachal Pradesh, my lord.
Okay.
And second, my lord, Chief Secretary, Government of Arunachal Pradesh, Vice Chancellor, Nehu, Shillong, my lord. No persons from the, my lord, any, my lord, public service body, my lord, for selecting civil post, my lord.
Public service body means?
Say, my lord, this is, my lord, practice that, my lord, in absence of, my lord, the member of the UPSC, my lord, as a chairperson, my lord, the neighboring, my lord, the members, from the neighboring states, my lord, the APCS chairmen are, my lord, requested to, my lord, chair the, my lord, selection screening committee, my lord.
Where is such provision?
There is no provision, my lord, but my lord, as a, my lord, practice, my lord.
Oh,
Because, my lord, one person has to be of the, my lord, experience having, my lord, selecting civil post, my lord. Well, thereafter, my lord, I have filed, my lord, an RTA application, my lord. How, my lord? Respondent number, my lord.
Now, what
Six-
happened to the result? Selection? Thereafter, who was selected?
My lord, one Shankar Santanu Dayal, my lord. Lordship will find at page 81, my lord.
81.
Yes, my lord.
Okay. So the selection concluded by this
Then-
notification.
Yes, my lord.
Page 81.
Yes, my lord.
Yes.
Then I filed an RTA, my lord, regarding, my lord, the process for selection of the, my lord, chairman, where I am concerned with the chairman only, my lord. Now, my
Okay.
lord, the page 86 onward, my lord, on RTA, my lord, lordship would find
86.
86 onward, my lord.
Yes.
86 is my lord. I received the reply, my lord. My lord, from the, my lord, note 85 onward, my lord, the lordship will find note 85 is at page. Well, page 85, my lord, sorry, my lord, page 85 onwards, my lord.
Ah.
Altogether, my lord. uh, At page 89, my lord. Altogether, my lord, page 89, my lord, my lord. After second line, my lord, Roman 1, application received for post of chairperson are 18 in numbers. Application received for the post of 3 members are 58 numbers, my lord. Altogether, my lord. Now, my lord, lordship will kindly come to page, my lord. 95, my lord.
Yes.
Note 83, my lord. Minutes of screening committee for screening application received for appointment of chairman and members held on 12/1/2023. As approved, the screening committee was reconstituted. Meeting of the committee was held on 12/1/2023. The committee screened, examined all 18 applications received for the post of chairman and APCSC and 58 applications received for the 3 vacant posts of members of APSC, my lord. My lord, this exercise was done on my lord 12/1/2023, my lord. My lord, now my lord, the new, my lord, the committee for screening committee was constituted, my lord, only on 11/1/2023. Lords, you will find at page 75, my lord.
New screening committee.
New screening committee, whoever, my lord, earlier retired, my lord, chairman of the UPC has been, my lord, replaced by the one Ramesh Negi, IS officer, my lord.
That is page 75.
75, my lord.
11 January.
Yes, my lord.
Yes.
11 January. And my lord, there is so much hurry in selecting the, my lord, chairpersons, my lord. On, my lord, 12th, my lord.
Yes.
The screening committee held, my lord. And on the 12th, my lord, altogether for the post of, my lord, 18, my chairman, my lord, 18 candidates are submitted. And for the post of, my lord, members, 58 applications, my lord. When the Supreme Court says, my lord, even if absence of the, my lord, memorandum of procedure, my lord, there have to be, my lord, subjective delivery and objective delivery of the selection.
We'll come to that debate later.
My lord.
What prejudice has been caused to you by this?
Because, my lord, will come, my lord. The screening committee has, my lord, sent, my lord, only one name, recommended only one name before the government, my lord.
For which post? Chairman.
For chairman, my lord.
Okay.
And in respect of the members, my lord,
So, according to you, you had applied for chairman.
Chairman, my
You
lord.
forget about the member part.
My lord.
Okay. According to this, how many members would have been recommended by this
Well,
selection
because, my
committee?
lord, there is no, my lord, procedure, my lord, memorandum of procedure, my lord. But, my lord, what they had done, in the recommendation, my lord, only says that on alphabetically name has been sent, my lord.
Alphabetically?
Yes, my lord. Name has been recommended alphabetically, my lord.
Your name has also been recommended.
No, my lord. Only one name has been recommended alphabetically, my lord.
So there's no question of alphabetical
Yes, my lord.
recommendation.
That's why, my lord. The merit has not been considered, my lord.
Where?
Lordship will find. Recommendation, my lord. A bottom of the same page 95, my lord.
95.
The committee considering all the aspects recommended names of the following applicants for decision by the government: Chairman, Lieutenant Santanu Dayal, and my lord, Lordship will find. The recommendation of the committee is further subject to clearance of police. My lord may escape.
You are challenging the recommendation of this man.
Yes,
Has-
yes, my lord.
Chairman.
Yes, my lord.
Has he been appointed?
My lord, he was appointed, my lord. Appointed by my lord. Swearing in ceremony was scheduled to be held on 17 to 2023, my lord.
Okay.
Because of the my lord, pressure exerted by the my lord, the communities, my lord, unions, my lord. Ultimately, the judge has been recalled, my lord.
Okay.
So, my lord, because no oath taking ceremony has been held, my lord, so he is not been appointed, my lord. Not been appointed in terms of the my lord.
Not been
Article
appointed.
316, my lord.
They are going to appoint him.
No, my lord. Thereafter, my lord, what happened, my lord? Again, my lord, after recalling the swearing in ceremony, my lord, again, my lord, the state has issued, my lord, fresh advertisement, my lord, for selection of the chairman and 3 other members, my lord.
So what will happen to this man?
Well, he has not approached the court, my lord, but other members who were appointed, my lord.
You forget about the members.
My lord, they have.
Don't poke your nose where you are not required to.
Because, my lord, my lord, there is a stay order from this honorable court, my lord, staying there, my
We will
lord.
confine to chairman, Mr. Chairman.
Chairman, my lord.
You want to be chairman or a member?
Chairman, only chairman.
Okay, let us confine to the chairman.
My lord.
Yes.
And my lord, kindly see the notes, my lord. In fact, my
No,
lord.
no. Has he been appointed now?
No, my lord.
Okay. So you want his
Because
selection to be set aside?
selection to be set aside, my lord.
Okay.
At this stage, my lord, notice may be issued,
No, no,
my
no.
lord.
We will not issue notice like this.
My lord.
He has been selected.
Selected,
Appointment order has been issued.
issued,
He could not be sworn in.
Yes.
Then what happened thereafter?
Therefore, cabinet has recalled that, my lord, swearing in ceremony process, my lord.
Let us see that order.
Lordship will find.
Don't hide anything from this court.
No, 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 my lord.
You will be in trouble if you hide
No, no,
anything.
no.
Yes. Notice is not that easy in this kind of a case.
Page 84, my lord.
Yes. Page 84.
Type copies, lordship will find at page 85, my lord. Decision of the cabinet, my lord. Minutes of the emergency state cabinet meeting by the virtual held on 17 February 2023 at such and such. In view of the request placed by the Arunachal Indigenous Tribes Forum and the PAN Arunachal Joint Steering Committee, the cabinet has decided to call off the swearing in ceremony of the chairman and members of the Arunachal Pradesh Public Service Commission. It was
Yes.
further decided that this matter will be discussed with all community-based organizations and stakeholders.
Okay.
My lord, I have also filed, initially I also filed a writ petition challenging the appointment, my lord.
Thereafter what happened?
My lord, thereafter, my lord, a fresh advertisement was issued, my lord.
Okay. Where is that?
Lordship will find on the page 114, my lord.
114. 114.
114, my lord.
So without cancelling his appointment order,
Yes, my lord.
huh?
Yes, my lord.
His appointment order has not been cancelled.
Not cancelled, my
Are
lord.
you sure, Mr. Sekya?
To my instruction, my lord.
We'll impose a heavy cost if you, huh? Matters are pending.
Yes, my lord.
Yes, Mr. Ratan. Has the appointment of the chairman, appointment order of the chairman has been cancelled or not?
My lord will see page 113
113. Yes,
in 18 April 2022.
Yes, sorry, my lord.
In the interest of
it
public
has the recall.
Recall, my lord. That's all.
Yes,
Is
my lord.
not it?
Recall, my lord.
Recall means cancel.
Oh, obviously, my lord.
Huh? No, there is a difference between cancellation and recall.
There is a difference, but
See,
effect is the same. my lord.
how could there be a fresh advertisement
Yes.
without recalling or cancelling the earlier appointment order? That is what court was,
my-
huh? At page 113. You have been instructed at page 113. Though his appointment order has been cancelled.
Recall, my lord.
So insofar as your grievance of you being not selected or challenged to the appointment of this respondent, a
Right.
chairman, ends there. That chapter
Ends
is
there.
closed now.
My lord.
So far what you have argued has gone in vain,
My lord.
gone to the wind.
My lord.
Yes. Now
Yes.
what is your next challenge?
My next ground is, my lord, the fresh advertisement, my lord.
You are challenging the fresh advertisement.
Yes, ma'am.
Have you
My lord,
applied?
In a abundant question, my lord, I have challenged these things, my lord, because, my lord, the other members says, my lord, to file the repetition, my lord, challenging the awards, advertisement.
You are for member or chairman?
I'm chairman, my lord.
Okay, chairman. Yes.
Ultimately, my lord, that, my lord, advertisement was issued, my lord, state, my lord.
Advertisement, okay. The advertisement has been stated.
Issued, my lord. And, my lord, the consequences will be that, my lord. The members, my lord, who were appointed persons to earlier advertisement, my lord. If success, my lord, they will be, my lord, again, my lord, appointed as a members, my lord.
Members.
Of course, my lord, the chairman has not challenged, the person who has been selected as the chairman has not come before this honorable court, my lord. But for an abundant question, my lord, if the, my lord, all the appointments are being, my lord, upheld, my lord, and the fresh advertisement has been, my lord, cancelled, my lord, at this honorable court, my lord. Then, my, for an abundant question, my lord, I filed this requisition, my lord. Okay, because earlier.
Praying for what?
Because earlier also had challenged the appointment of the chairman, my lord. That appointment, my lord, that requisition has been withdrawn by me. On the ground that, my lord, because, my lord, the swearing in ceremony has been, my lord, the recall.
No, they are all now history now.
History, my lord.
Now you have filed this writ petition, you said by way of an abundant counsel.
Abundant question,
What
my
is
lord.
your prayer?
Prayer, my lord. Of course, my lord. Now the prayer is, my lord, to set aside the, my lord, advertisement, my lord.
To set aside advertisement.
The fresh advertisement.
What is the ground of challenge to this advertisement?
Ground is, my lord.
Because all the arguments which you have made insofar as appointment of a chairman, earlier order,
My lord.
is of no relevance to this.
Yes.
Okay, all right, yes. Now we proceed appraise.
My lord.
Yes.
Now, my on limited ground, my lord. Suppose in the event, my lord, the respondent number 6 challenges, my lord,
You address your ground of challenge to this advertisement.
This is along with that, my lord. My lord, the state has not, my lord, followed, my lord, prepared any memorandum of procedure, my lord, for selecting the, my lord, chairman, my lord. In terms of the, my lord, decision rendered by the.
Let us see the decision. Your prayer is for preparation of a memorandum of procedure.
Yes, my lord. Only thereafter, my lord, the fresh advertisement
Can be issued according to you. Let us see your prayer in the decision.
My lord, the judgment, my lord.
Just a moment. This advertisement is a subject has been stayed by division bench. That matter is pending.
Pending one.
Then you approach there. Then,
Appeal is not pending.
huh?
Appeal is not pending.
Oh, that's it. Appeal is not pending. Oh, till
Yeah.
disposal of those writ petition.
Yes.
It has been stayed. So that has been stayed.
Yes.
Let us first see your pleading. Insofar as the advertisement is concerned.
My lord.
Have you filed application? Have you
Yes,
applied?
My lord.
Have you applied for the post of chairman?
No, my lord.
You intend to apply or not?
No, my lord. My lord. I have not applied, my lord.
Then what locus you will have? You want to be selected as the chairman on the basis of some guidelines, some memorandum of procedure prescribed by the state,
My lord.
which according to you is not there.
My lord. Till
Un-
my-
So
till
you,
date, I have not, my lord, applied, my lord. And last date is my lord, 31st, my lord.
31st of July, you apply and then come back. You may apply, you may not apply.
My lord, we may have all apply, my lord, but
One who is not a candidate pursuant to an advertisement, how can he pray for some guidelines there?
my lord, because my lord.
As a public spirited person, you may say so. But this is not a public interest litigation. Because your first prayer is gone. We are on the second prayer in advertisement. And where is the requirement for preparation of a guideline? You are referring to one Supreme Court
Supreme Court
judgment.
judgment, my lord, sir. In fact, my lord, one PL is also being filed before this honorable court, my lord, for compliance of the honorable Supreme Court, my lord, which is, my lord, we will, I think, my lord, come up within 1 or 2 days, my lord.
But here, in so far as you are concerned, you don't have a locus to say so. You should be first applicant, I think. Then you say, no, I have offered my candidature, but I find there is no any criteria. And there has to be a criteria under something.
In this event, my lord, my kindly it takes after 2 days, I will take instruction. my lord.
Okay. When?
After 3 days, my lord.
After 3 days, the prayer of Mr. Asika, the council for the list after 3 days.
I've received. It will be taken after the next case.
After next case.
It's being printed.
I'm challenging the document at page 72. Page 70.
My lord, as per the last order, I was supposed to obtain the instruction from the officials who has carried out this verification.
How will it carry out?
Yeah, the verification that is annexed in additional affidavit filed by the petitioner. Although I have not received the written instruction, yet I have obtained the verbal instruction. I have spoken to the official who has carried out the verification, and he has told me that yes, indeed, this order has been prepared by him only.
You are challenging what?
This document at page 72.
72 of the.
This petition. However, earlier I was allotted the plot of land. Now, on the complaint made by the executive engineer power department, this document was
sent to the Deputy Commissioner Eastern District. Then approval for cancellation of land allotment order. I am directed to refer to a letter number such and such cited above and to convey the government approval for cancellation of land allotment in the name of such and such, measuring such and such for residential purpose as conveyed by such and such. Further, the land revenue paid if any may also be refunded. Cancellation order may be issued from your end to the person concerned immediately after receipt of this order, and copy of the cancellation order may be forwarded to this office for records. This matter was issued by one R. Gini, who was the in charge director at the point of time. Substantive post is the joint director of land management. This was issued without conducting any inquiry on the complaint of the executive in the power department. It appears, my lord, subsequently, my lord, they have conducted an inquiry. They will also will find in my additional affidavit. At page 6, my lord.
Just a minute. Additional affidavit.
Yes, ma'am. Page 6, my lord. It's an inquiry report. By the same person who issued the impugn communication.
Yes.
Page 6. Relevant would be, my lord, closing remarks at page 7, my lord. Closing remarks.
Yes.
After carefully going through all the available relevant official documents and observation of ground facts, it is seen that the Department of Power has been casual and not serious for the plot site until the said plot was officially allotted to such and such. Also, it is learned that such and such in occupation from 2004-5 and was evicted by a state officer. Thus, there was ample time for Department of Power to have initiated for regulation of the occupied plot, considering the grave situation. Even the state government wide order number such and such, that all deputy commissioners with direction the allotment of land on the basis of approvals already conveyed by the government. Department should be issued without waiting for payment of land value. Land in actual occupation of various departments at all administrative headquarters should be surveyed and recommended approval to government for allotment. Pending government approval of land in occupation of government organization and department for allotment may be issued from the side. All additional deputy commissioners such and such should be instructed to carry the exercise within the jurisdiction. Details of land allotment to various government departments at each administrative headquarters should be complied department wise and submitted to directorate in order to enable directorate to write and concern departments and finance department budgetary provisions for payment of land value, etc. Process should be completed within 60 days. In compliance, the deputy commissioner Eastern District directed all the HODs head of office to detail representatives from the respective department to assist the LM staff, service staff or identifying concerned departments occupied plots for offices, quarters, and other establishment. Thereafter, a reminder is issued from the areas of East Siang, right, and such and such. The Department of Power has never took interest to regulate a disputed site until that is such and such, is such and such. Thereby, the private party took advantage of the given time and got the land allotment in his favor on that is such and such. Furthermore, I don't see any abnormalities on the ground. As per government order number such and such, the circular issued to all DCs, ADCs to mandatory maintain 4 meters of distances all around the government quarters buildings. Xerox copy the circular is an exercise. There are sufficient spaces and more than the required space is left for the government quarter. Physical photograph taken in presence of incoming is evidence in my bar. The boundary walls is 13 meters away from the government quarter. Now, after careful examination of the official records, executive engineer, such and such, I have not found any abnormality in allotment of the said government land plot through such and such. This allotment cancelled would be restored without any vacillation. So this is now the report of the person
Who had ordered the inquiry by this officer?
that I am not aware of. Earlier order was
Is there any reference to that in the earlier part of this report?
yeah, this my lord will kindly have page 6, my lord. It speaks of a reference to the government order number such and such dated 4/1/2019.
You were allotted land when?
I was allotted on my lord 16/3/2017.
16/3/2017.
My lord. The impugn communication is 19/9/2018.
19/9/2018.
18. Yes.
Now, what is this letter? Any idea? 4/1/2019?
My lord, I have no idea. My learned friend will be better.
Yes. What is this? 4/1/2019, and on what basis he has conducted this?
With this regard, Lordship, I also do not have idea, Lordship. I have not taken.
Okay, you have.
Yes.
They have refused
Yes,
to.
instruction of this.
Okay. Yes, Parme, what do you say? Your land has been allotted to this man.
No, they have no land allotment.
Okay. Just.
Not allotted to. It appears there is an order for this inquiry.
This 4/1/2019 order will throw some light.
But it appears it is an order for an inquiry.
Page 72 is the impugn order here,
My lord.
and it has been stated, is not it?
This is by the same authority who ultimately conducted the same officer who conducted the inquiry.
You said your allotment, earlier allotment was 16/3/2017 means issued by the deputy commissioner,
Yes. The approval was 15/3/20.
15/3.
Allotment order is 16.
Had Mr. Deep Bagul, counsel for the petitioner.
Sorry, my lord, disposing a case.
No, well, not this way. But even then, yes, what do you want to say?
No, my lord, though we are not only, we have already filed our apprehension.
Huh?
We have filed our apprehension opposition, my lord. Already,
By the power department.
Power department. That is on the record, my lord. We are saying, my lord, though that lane was not allotted to us, but we was in occupation of the lane, my lord.
Since when?
Since, my lord,
2000, my lord, since start. That apartment, my lord, specific apartment.
Okay, all right, you prepare your case for the next day.
In fact,
We have
Honorable,
discussed it.
we had obtained an order from this honorable court earlier also for consideration.
All right, and Ms. D. Bang, counsel for petitioner. Mr. D. Kamduk, London Standing Council for the Land Department, represent respondent 1, 2, 3, huh?
Yes, yes.
4 also.
4 also.
4. P. Pangu for 5 and 6. And Mr. L. Perme, London Standing Council for Power Deployment for R7. Yes. This writ petition has been filed by the petitioner challenging the letter dated 19 September 2018 written to the Deputy Commissioner East Siang District Pasighat by the Joint Director, in charge Director of Land Management, Government of Arunachal Pradesh, by number so inside page 72. Whereby a land measuring 450 square meters for residential purpose at Pasighat Township whereby approval for land measuring 450 square meters for residential purpose at Pasighat Township in favor of the petitioner as conveyed earlier by number LM 47/2012 within bracket volume 9 Roman 9 1771 dated 15/3/2017 has been approved for cancellation. Full stop. Mr. Kamduk,
Yes.
what is your contention in your affidavit, counter affidavit?
I have no filers.
Oh, no counter affidavit file?
Yes.
Okay, all right. Oh. Yes. Who has filed counter affidavit?
Only the power department.
Only for, you have also not filed.
We have filed your lawsuit.
Deputy Commissioner has filed.
The-
What has this Deputy Commissioner said in the affidavit file?
Yes. In our affidavit, we are saying
Affidavit,
that,
I have not been furnished a copy by the deputy commissioner. I only have the copy of the power department.
we are saying that the plot of land
that the petitioner occupied without allotment order is earmarked for the construction of residential building of government officer, Your Lordship.
Just a moment, just. And Mr. Kamlu,
Yes, Lord.
why the land management department is not filing an affidavit?
Here it discussed also.
Huh?
Here it discussed also.
Ah,
It discussed also, this. Where, not filed because also. Where, on this, paper, see, on this document only, also, for the last, 2-3 occasions.
see, it is, what is going on here on the additional affidavit file is on this last 2-3 occasions.
Yes.
This writ petition is of the year 2018.
That is true, Lord, also. That is, in fact, also.
Now we understand why you have not been furnished with the instruction also regarding this. Okay, all right. Just a moment. Deputy Commissioner is respondent number 6.
5, Your Lordship,
5.
and 6 also, Your Lordship.
6 is the other also. Okay. Both of them have filed together.
Yes, Your Lordship.
Okay, they are. Mr. Pangil, Bagra has received.
That's why I was telling that friend, most probably didn't give it to me. That's why.
Affid-
I will find it photocopy. Now.
Affidavit in opposition for D. Tamuk advocate by M. Bagra.
I will.
Yes. Okay. What does the deputy commissioner say? This deal also.
Saying that actually, Your Lordship, this one. That a plot of land that the petitioner occupied without allotment order is earmarked for construction of residential.
Paragraph
building.
number
Paragraph 7, Your Lordship.
7.
Oh, sorry, Your Lordship.
This is in response to what I have stated in the petition. This is not the step. Because in response to paragraph 7 only.
No.
Paragraph 7, I had most probably said that I have been in occupation since earlier. That is the response. That in to that extent is correct. But now I am challenging the cancellation.
Okay, all right. Power department has also filed, isn't it?
Power department.
Respondents.
Our complaint, my lord.
No, it's all right. Okay. 5 and 6. As well as respondent number 7. They have filed their counter affidavit. However, the Department of Land Management, the respondents 1 to 4 hearing, have not yet filed counter affidavit, though the writ petition pertains to the year 2018. No stop. While the counter affidavit by the Land Management Department has not yet been filed, is yet to be filed. The petitioner in the meanwhile has filed. And additional affidavit on 28 March 2023. However, a letter dated 16 January 2019 is stated to be written by the Joint Director, Directorate of Land Management, Government of Andhra Pradesh, the respondent number 4 hearing, to the Secretary, Department of Land Management, Government of Andhra Pradesh. Full stop. In the aforesaid letter dated, which has been annexed Annex 1 to the additional affidavit. In the aforesaid letter dated 16 January 2019. The respondent number 4 in his letter, in his letter. Has stated that he has not found any abnormality in allotment of the said government plot to Sri Tamio Tatak of Rani village, the petitioner hearing, and his land allotment cancelled by number LM 47/2012, volume 9/1091, dated 19/9/2018. This is 19/9/2018 is the cancellation order.
Yes.
But he said the cancellation order could be restored. Place that annexed J could be restored without any vacillation. Have you read?
Yes, but English is not that great, but.
No.
What he means.
See, we were all throughout under the impression that your earlier allotment order could be restored.
Yes, I understand what your lord.
Now we have found that your cancellation order can be restored. That means your cancellation order is still.
He says land allotment cancelled. It appears so from this, but your lordship will see. He said I have not found any abnormality. So from this now they will to clarify this. He said I have not found any abnormality in the allotment. It appears it has not been finally ordered. It appears that what is to be restored is actually the.
So this last sentence runs contrary to the preceding sentence.
Yes.
Okay, you write like this. Dated 19/9/2018 could be restored without vacillation. Okay. So we require all the more instruction, Mr. Yes, without vacillation. Paragraph from the above. From the above, it can be seen that the respondent number 4, while stating that he does not find any abnormality in allotment of the said land to the petitioner, but at the same time, he also says that the petitioner's land allotment cancelled by number LM 47/212.
I'm sorry for interrupting.
Ah.
It appears what he's saying is to just cancel could be restored. Because the allotment was cancelled by this order could be restored. It appears that is what he's saying.
Okay, let us, okay, then you start of this last part. From. Okay. Since the counter affidavit remained not filed by the Department of LM, Mr. D. Kamdu, London Standing Council for Land Management Department was granted 1 week time to receive instruction on the additional affidavit filed by the petitioner. Petitioner by order dated 25/5/2023. When this matter was taken up on 10/7/2023, Mr. Kamdu, London Standing Council for the Language Department submitted that he is yet to be furnished with the instruction on the additional affidavit filed by the petitioner in terms of the order dated 25/5/2021, for which he was granted further time to receive instruction, and the matter was directed to be listed on 24/7/2023. Today also, when the matter is called up, Mr. Kamdu, Northern Standing Council for the LM submits that he has not yet been furnished with the written instruction by the respondent number 4, but he has been verbally informed.
Yes, sir.
That the letter dated 16 January 2019, annexed by the petitioner in the additional affidavit file, was written by him.
Yes.
Okay. Full stop.
And he also said that he took up the verification and this report was prepared by him only.
Full stop. Letter dated 16 January 2019, written by the respondent number 4 to the secretary to the Government Land Department, appears to be an inquiry report on the land allotted to the petitioner. Full stop. In the absence of a counter affidavit filed by the Department of Land Management and a written instruction provided by the respondent number 4 regarding the inquiry report, dated 16 January 2019, annexed by the petitioner in the additional affidavit file, it is not understood as under which authority the inquiry report dated 16 January 2019 was submitted by the respondent number 4 to the secretary LM, Government of Administrative Affairs. Under the circumstances, since neither any counter affidavits have been filed by the Department of Land Management, nor written instruction on the inquiry report dated 16 January 2019 has been furnished by the respondent number 4. This court has comma in order comma for proper adjudication of the matter, comma. This court has no option but to requisition the presence of the respondent number 4 to answer the writ petition as well as the to answer the contentions raised in the writ petition as well as in the additional affidavit filed by the petitioner. While granting liberty to the Department of Land Management to file counter affidavit if so advised on or before the next date fixed. The respondent number 4. He is still the joint director?
Yes, sir.
Okay, the joint director, land management, no, joint director, Directorate of Land Management Department, is not it?
Yes, sir.
Government of Arunachal Pradesh shall remain in person, remain present in person before this court at 10:15 a.m. on 7th August 2023. Along with all the relevant records to answer the contentions raised by the petitioner in the writ petition as well as in the counter affidavit file, sorry, additional affidavit file. This is on 7th August.
If we could give some more time, instead of asking for this personal appearance loss, if one time may be granted
Shall we make it 1st of August?
for filing of this lawsuit affidavit also.
No, that is up to you. See, we can't force you to file an affidavit.
No, lawsuit by
It is up to you, but we will require answer to the issues raised by the petitioner to decide, not for anything else, but to determine. Is not it? Okay, so yes, next slide. See, just a moment. Mr. Kamduk,
Yes, sir.
we'll give you a copy of the order.
Yes, sir.
lawsuit may participate.
Copy of this order will be furnished to Mr. Kamduk under the Standing Council LM for onward communication to respondent number 4.
Yes.
For doing the needful as well as for onward communication to the respondent number 4. Yes.
Find the number. These are the private for the private respondents activity.
David Tagbu.
One is lawsuit, MS Furniture Traders, other one is MS Continental.
Where? This one?
Close.
Where is the number? Huh?
On the top. On left hand side also, first page, 6 and next is 6
This was before whom?
This is before the activity.
Bolen. Both, no?
Both.
And your affidavit was when?
Lordship, it was Pasiga.
There appears to be some number here.
And the other activities which are written those capital complex. Where number is given. Is everywhere also epidemic, the number is used to be given.
Lordship, as per the instruction, I have been told that since that particular number has to be, as per the demands of the respondent authority, it should have been written on the top. That was there, however, in the capital complex affidavit, before the capital complex, the number used to be given below, down below. And as far as the petitioner is concerned, his affidavit, that round seal was there in the stamp paper. And there, the number was there, however, the number was not mentioned in the top, and that was the basic ground for rejection of this affidavit. Lordship. I mean, on the basis of the respondent authority, and may I take lordship to the affidavit format of the affidavit, which is at 118 lordship. 118 of my writ petition law.
Yes.
Lordship, this is the format of the affidavit. Here, as far as the petitioner is concerned, he has copied this entire thing, and then the affidavit number that was not only reflected on the top of the affidavit of the stamp paper, Lordship. And moreover, the lordship, there is
The
no
number, see, number. Why they are asking for number is, the number will indicate that you have actually shown an affidavit before that office.
Yes, lordship.
That appears to be a legitimate ground.
May if your lordship may allow.
What is that?
Lordship, this is the affidavit executed by the petitioner. Not with regards to this present NIT, but this is the normal affidavit. Sorry, before the executive magistrate, where the number is reflected down in between the stamp paper and the contents of the affidavit, Lordship. So as far as the petitioner is concerned, he has not numbered, that affidavit was not numbered on the top, but however, this number was, as far as the petitioner is concerned, this number was given below.
This will be a messed up in substantial ground.
Because the registration itself is the very entity of the affidavit. Otherwise, if anyone can produce such sort of affidavit.
Okay, you file affidavit then. In the meantime, what is this? Don't finalize. Don't open the financial bill.
Financial bit has been opened, Lordship.
Has been opened?
Yes, on 12th.
Okay.
On 12th.
You had also submitted your financial bid.
Yes, it was into envelope system, so I have submitted.
Don't finalize in the meantime.
Apparently, the condition has been given also. It has not been fulfilled.
No, see, today you have brought what? Documents sent on a WhatsApp.
No,
So this may be correct. We are not saying that this may not be correct.
sir. Let's forget about this affidavit.
Yes.
Affidavit of the petitioner, whether that fulfills the conditions laid down in the NIT or not.
No, his allegation is that the affidavit of these two respondents were same as his, not numbered. But you have produced on the document, this affidavit taken out from WhatsApp message sent, where some number is indicated. You know the evidence is value of photocopy. Is not it?
No, sir, at least I'm submitting before this order.
Okay, then you produce the original record when?
Tomorrow.
Tomorrow. Okay. We'll see the original records.
Oh, I am objecting the law. At least process.
And see this number is also what kind of a number? This said there is a number. This said there is a date. Now he has given one instance. Numbering. this may be the procedure followed in that office, but
Proper numbering is concerned. It can be anywhere.
no.
But that number,
See,
registration number and then.
What I'm saying is, see, here, numbering is done in this manner. There is a seal
Close,
in the photo. Then there is a registration number,
close,
date.
date,
Then it appears to be more authenticate.
close. This is also close, it's correct also. Because what I'm submitting close, it can be in any manner also.
Where is the record? In Itanagar?
Record is not in Itanagar.
Okay.
Yeah, it's kind.
Huh?
Itanagar.
Tomorrow will it be possible? Day after tomorrow. Status quo.
Yes.
You are not going to issue work order tomorrow.
That is true.
Okay.
When the conditions have not been fulfilled also.
तब तक अपील listed on give the date there to tomorrow
26.
26 to enable Mr. Tapin, non-listening governor is okay to produce the original record. Which contains the affidavit submitted by the respondents 6 and 7.
Yes.
Respondent number
Respondent number 7 and 8.
7 and 8 in the bid submitted by them pursuant to in the bid in the bids submitted pursuant to NIT dated
23/6.
23/6 page number
Page number lordship 32.
32. Dated so and so, issued by so and so, executive in the Central Division, AP and WCL, etc. Till then, the status quo with regard to the NIT dated so and so, issued by so and so, be maintained.
Be clear.
Yes. What is this matter?
My lord, this is petition challenging the appointment of the private respondent in the DRDA administration, regular appointment of the.
Status quo is on today. Status quo is on today. Yes.
I'm appearing on behalf of Mr. B. Picha, who is the standing counsel for RD.
Okay.
Lordship, he's out of station. Can it be posted for some another date, Lordship?
All right. Mr. Tiomo. Counsel for the petition.
My lord, a fixed date maybe.
Huh?
A fixed date maybe, and because in the last occasion,
Who represents respondent number 7? I think SK Theory.
SK. SK Deori. Anybody appearing for Deori? He's still working.
My lord, although there is no record as to the petitioner about the status of the privatization. However, in summary, in the last occasion or prior to that, the council for the respondent has stated that the person is still working as a technical assistant, meaning thereby he came back to the previous post from where he was appointed as a to the present the impugn order. So as of now,
So that means he is not working in the post whose appointment you have challenged.
yes, no, not working.
All right. On the prayer made on behalf of Mr. Picha, London Standing Council for RD Department by Mr. J. Zini, Council, listed up the 4 weeks.
My lord, let it be on 7th of August.
7th of August, why?
My lord, this matter is of 2020, and the issue here is very simple, my lord. In fact, there is a stay order also, which I am enjoying. But then
17th of August. Okay. Huh? 17th August, okay. All right.
my lord,
Jini?
lordship, prior lordship, any date, lordship. Prior, so then, my lord, first week of August, before 10 or
Okay, in the first week of August.
lordship. All right. Much of.
Yes.
Lordship, respondent authorities, they are yet to file their affidavit.
Ma'am, lordship, we need some more time to file affidavit.
All right. Okay. This the council for the petitioner. And Ms. K. Olmo, government advocate, representing respondent 1, 3 and 4.
Yes, ma'am.
Who press for any granted further 8 weeks time to file counter agreement. Let's sit up the 8 weeks.
Much of.
This matter pertains to the same compensation, NS 15 415. It may be listed after 2 weeks, when all the affidavits are filed. I will take all of them together. Similar matters are.
We could have taken.
No, so in some cases affidavits are not have not been filed. So here affidavit has been filed, man.
Here affidavit has been
Yes,
filed.
madam. It's some other cases affidavit are not there, man. So let the affidavits filed be in all the cases, man. I will take all of them together.
When are they?
It has been last month ordered up list after 2 weeks. That's fine, man.
Earlier,
Yes,
earlier case also.
Yes, man. That's fine.
Yes, but with double list of 2 weeks. All right.
Yes, obliged.
My lord, here I seek some more time to file affidavit in reply. In fact, my lord, petitioner is posted at Delhi. Had authorized one of his nephews, who also works in the police department, to sign the affidavit. But he has now got some difficulty, some suspension, something like that.
All right. You, okay, on the prayer of Mr. D. Pangal and the council for the petitioner, listed up the, we'll say 6 weeks,
4 weeks, my
4 weeks. For filing of a rejoinder to the counter affidavit filed by the state.
state.
Okay.
Problem.
Yes, what is this?
Your Lordship, this is regarding promotion, Your Lordship. Here, I would pray Your Lordship to give me time to file a reply, affidavit reply, not yet filed, Your Lordship.
From which post to which post?
Petitioner was in the rank of ASI Telecom.
Okay, all right.
Mr. A. Bachcha is another counsel for the petitioner, prays for and is granted further 8 weeks time to file rejoinder to the counter evidence filed by the state. State, no? Instead after 8 weeks.
Item number 11.
Yes.
No, this is in order stage.
Ah.
I was away in the principal bench on 28th.
Ah.
So this is fixed today for what purpose that I have not
For
been.
disposal, my lord. Lordship, this was Lordship last Friday said, my lord, because they were challenging the jurisdiction of the Women Commission, my lord. So.
Women Commission.
Yes, my lord.
You are representing Women Commission.
No, I'm representing respondent number 2, Women Commission also.
Ah.
Then
On behalf of respondent 2, we have filed our affidavit.
there is a conflict of interest.
No,
You are representing Women Commission and private respondent. What kind of thing is this?
Oh, this.
So, my lord, the petitioner resides in Bandadeva, he's working as constable in the police department. Or like,
No, it is my case. If I have to argue, I have to start.
well, that's why I'm reminding my last time's proceeding because he was not there.
Okay. Respondent number 3 is the wife of
Yes.
petitioner number 1, sorry, 3. And petitioner 1 and 2 are who? Who are they?
They are elder sister and the younger sister.
Of petitioner number 3.
Three.
Okay.
Well, there is a paucity of time.
Ah.
If I can be accommodated for some other day, at least for a week or so, if I'm accommodated kindly.
Yes, Tabo. To that extent, Tara is correct. Today we have we have
Alright,
paucity of time.
Yes.
2 weeks.
2 weeks is fine.
Oh. The prayer council to the parties listed after 2 weeks.
Grateful.
Item number 12.
Paucity of time. Reviews.
Tomorrow.
Not tomorrow.
Lordship, I'm
Okay.
requesting this honor code.
Okay,
Lordship.
after a week,
Tomorrow, Lordship, please.
tomorrow.
Because it was listed yesterday, so because could not be
It
taken
was
up.
listed yesterday,
Sorry, it was Friday, I think.
Friday.
Tomorrow, I request.
Tomorrow, okay,
Yes, sir.
tomorrow. See, for listing tomorrow also, it is too late in the day. Day after tomorrow,
Day after tomorrow, no issue, no issue.
day after tomorrow.
Item number 13.
I am extremely sorry, Milad.
Ah.
This 19 and 20 also, Milad. Is there anyone from Smart City?
19 and 20? No,
This IA was for
no,
implement.
no, let us go serially.
Oh, no,
It will not be fair.
Oh, no, I thought of paucity of time.
No, let
Uh,
us see.
uh,
Item 13.
Okay.
Lordship, item number 13, state are to file their affidavit. File it. Yes, then file.
Miss,
Item 13.
yes. Miss G, I think. No, somebody has filed affidavit, I think, R3. Who is R3?
Item number 13, Lordship.
Huh?
Item number 13.
Oh, private respondent. Yes, item 13.
Respondent number 3, I think, filed.
Yes. What is your prayer?
We have not, we haven't filed, but then Lordship, the case hearing is that Lordship. This respondent number, this private respondent number and petitioner are brothers. Then this is compensation matter, Lordship, payment of, non-payment of compensation matter.
Oh.
So there was a Lordship complaint from the brother not to disperse the compensation amount to his other brother, the petitioner. So we kept it in abeyance.
Who is for 3?
Now he says, Lordship, we have paid already. I have
To whom you have paid?
to the petitioner lordship, so far.
Yes, Mister.
I have taken,
Lordship,
You have received the money.
Lordship, 20% of the money was not paid, Lordship.
20% of the money. was
Lordship.
paid already that amount.
That we have considered, Lordship, on 27th January 2023, the payment was made, Lordship.
According to the
But then this 20% of the
Yes.
money that was paid on January, for the last 2 years and 8 months and 30 days, they have delayed in the payment, they have delayed the payment. So why I have sought for interest of this amount,
lordship,
Lordship.
that's not because of,
So why this matter is still pending, Lordship? So last occasions, Lordship may kindly see that there was an order from this honorable court to file affidavit in opposition in respect of that, Lordship, in interest only, Lordship. We have considered the amount we have received, Lordship. Now here, this case is still surviving for determining the interest, Lordship.
lordship may kindly also peruse that private respondent's affidavit, lordship. There he have said now. He doesn't have any objection to the payment, lordship. That's why we have given. There was, lordship,
Why have you made
this
the
agreement between the brothers, lordship.
respondent number 3 a party?
Lordship, this actually
of
this
him only.
matter is taken up by one of my friend, Lordship, Mr. Picha, Lordship.
He is asked, this is for payment of 20%. No.
Interest, Lordship.
They are asking for interest now for this 20% payment.
Lordship, what had happened is during the pendency of this case, the 20% amount was paid. But along with the 20% compensation amount that was not released, we have sought for interest also, Lordship. This matter is still pending for determining the interest only, Lordship, now.
Interest under which provision?
Lordship, then my learned friend will be the better person to apprise this honorable court, Lordship.
I think there is one
Yes, sir.
provision in the act.
Lordship,
It's
there are
there, but then
provisions.
lordship, last time occasion also I have submitted that this was pending because of their disagreement between the brothers only.
Oh,
This private
So
respondent brother.
they have to
brought
come with the affidavit, Lordship. Last
Lordship,
occasion,
brought
they
to
have
the
sought
deputy
time.
commissioner saying that that's why they have made him a party also here, lordship. Otherwise, he cannot be a party here. In his affidavit, he have said that he have no objection to the payment of the 20% to the petitioner now.
okay, on the prayer of Mr. J. Jindal Constitution, listed after 6 weeks.
No, Lordship, not 6 weeks, Lord. Let it be after 3 weeks, Lord.
So where is your counsel?
He's in Guwahati, Lordship. So it's
Oh, after 4
Be
weeks.
patient.
4 weeks. Lordship.
4 weeks.
much of.
She may be right. Both of you were fighting, that's why it was delayed.
That's why, lordship.
Lordship, whatever may be the reason, Lordship, they have to come up with the affidavit, Lord.
You may file an affidavit.
Lordship.
Lordship.
Yes.
What in this case, 3 affidavits have been filed by the respondents, including private respondent number 11. And respondent number 2 and 5 have not filed any affidavit till today.
In the writ petition.
In the writ petition. And therefore 3 affidavits I have received. Against that, I will file affidavit in reply, Lordship.
Okay.
And
How much time?
4 weeks. And the date may be
I
fixed
have
on.
already filed, lordship.
Yes, I have.
Yes.
On the prayer of Miss L. Day, when it comes to for the petitioner listed after 4 weeks.
Okay.
On fixed at 28, because another item was,
Huh?
another item was listed before on honorable court number 2.
4 weeks.
28/8, Lordship.
Oh, 28/8.
Yeah,
Okay,
yes.
listed on 28/8. For
Affidavit reply.
filing of rejoinder to the counter affidavit filed by the state
State and private respondent.
as well as the private respondent.
Yes, Lordship. Interim order may be continued till then.
Okay. Interim order passed earlier, shall continue till the next date of listing.
Yes, Lordship.
My lord, earlier in writ petition number 748 of 2017, which has been annexed as annexure here in this writ petition lordship.
Ah.
I was the counsel for the petitioner lordship
Ah,
in that case.
ah.
Now, since they are relying on the order passed in that writ petition, Lordship,
Okay.
I may not be able to, it may not be appropriate for me to appear for the department also in this case,
So
because
you sort it out with the department?
therefore, Lordship, I have already conveyed to the department, and department has instructed me to engage the government counsel, who is representing Deputy Commissioner and other respondents.
Okay, Miss Ete.
Yes.
Okay, all right, we'll hear it.
And in that may be recorded, Lordship.
Okay, all right. Mr. D. Kamdu, Standing Counsel for Language Department, in the meanwhile has pointed out that the petitioner is relying on an earlier order of this court passed in
WPC number
WPC
748.
748.
Yes, of 2018.
2018, in which writ petition he had appeared for the petitioner.
Yes, Lordship.
Also, in that view of the matter, he submits that it may not be appropriate for him to represent the Department of Land Management in the instant case, which was duly informed to the Department of Land Management, upon which the Department of Land Management has instructed the government advocate.
Yes, Lordship.
Government advocate to represent the Department of Land Management. So in that view of the matter, Ms. G. Ete, additional senior government advocate, will also represent the Department of Land Management in the instant writ petition. All right.
Five Lordship. I will accordingly, Lordship, I will take instruction.
Okay.
Lordship, in this case, IA number 202. My runner friend supposed to file an affidavit in opposition.
202. Oh, Lordship, this is last time, because of that only I was objecting this Lordship IA. After filing of. all
Okay,
the
we'll-
affidavits,
we'll-
only
No, that affidavit.
We'll consider on the next day.
Yes, Lordship.
First, you file your rejoinder. We'll
Yes,
consider
Lordship.
next.
And the second, 15, item number 15 also, contempt matter, I will have to file
List it on 18.
Reply.
28.
reply, same day,
Okay, 20.
public, 28. Yes, 4 weeks.
Item number 16.
My lord. Yeah, please, my lord.
You have not taken the steps
Yes, the step has not yet taken.
for service of notice on respondent number 6. Who is 6?
Is Minto Dichi, sir. Your Honor.
Anybody appearing for respondent number 6? No. Mr. Your name?
M. Kambo.
M. Kambo.
Yes.
What is your prayer? On
I
behalf,
may be given some more time.
appearing on behalf of Mr. M. Nebo, London
Yes.
Council for Petition has sought for an adjournment. Also, however, on procedural of office now dated 21/7/2023, it appears that the petitioner is yet to take fresh steps for service of notice upon respondent number 6. In that view of the matter, 1 week further time is granted to the petitioner to take fresh steps for service of notice upon respondent number 6 by both ways, listed after 8 weeks. You have understood?
Yes.
Notice is to be served to respondent number 6, for which you are required to take steps. Submit the notice to the registry. Inform the senior.
Lordship, this review petition, Lordship. This was second last occasion, Lordship. I've checked the records and he has already received an acknowledgement and come back, Lordship.
Okay. We Gesum Enterprise.
Lordship.
Okay. What is to be reviewed?
Yeah, Lordship, direction was to open the tender and to decide the issue, Lordship.
Result declared shall be duly notified and put off. Yes.
But pertaining to this very Lordship, area Lordship, lane issue Lordship, forest reservation issue, there was one litigation pending before the NGT Lordship. where interim order is there, lordship, not to make any activities within the area, lordship. Where the lordship deputy commissioner is also a party, lordship, in that case, lordship. And that was, lordship, suppressed in the sense it was not placed along with the writ petition, which led to passing of this order, lordship. The order of the NGT, lordship, is at page 18.
Page 18.
Page 18, lordship. Otherwise, the order of this honorable court is at page 15, lordship. And relevant is
This petitioner,
he was one of the bidder, lordship, writ petitioner, lordship.
he was not a party in the NGT.
Petitioner was not the party in the NGT, lordship. But the respondent is the party in the NGT, lordship.
Sorry, this Gesum Enterprise.
Gesum was not the party in the NGT, lordship.
Then who is party before the NGT?
NGT, lordship, kindly come to page 18, lordship.
Yes, Mirzum Karwa.
One Mirzum Karwa, lordship, Union of Indian others, lordship. In others, lordship, state of political parties also is there, lordship.
State is a party.
State also is a party, lordship.
So
So
this Gesum was not a party.
no, Gesum was not the party. Among the development activities, lordship, this is the only one lordship project, lordship.
Where is that order of the NGT?
NGT, at page 18, lordship.
Relevant part.
Relevant is paragraph 6, lordship, at page 19.
In this view, domain with directive further order, there shall be a complete history on all consecutive activities. 25/10/2022. What is this notification?
This is lordship. This is regarding lordship.
Okay, let it come up after 2
lordship,
weeks. Let it come up after 2 weeks.
otherwise, lordship,
This petition, this respondent might appear also. What is the AD card?
otherwise, from the reading of this very order, it's very clear, lordship.
But what is that order?
Lordship,
What is the AD card? What is this area? Sorry, government notification that is 25/10/2022.
lordship, this 25/10/2022, lordship, that has not been annexed here, lordship. But if lordship,
Land measuring.
if lordship read the lordship paragraph 5, lordship,
Paragraph 3.
paragraph 3 onwards, lordship.
Located at Jaji Rijo, Lipin, Birko and Boko area at CG Market Discovery.
Hello, paragraph 3, lordship.
Okay, then what was the NIT for?
NIT was for constructions of road losses.
Then why did you invite the NIT? When any construction
Losses.
was prohibited in those area, why did you invite NIT?
If losses is the NIT,
Likavali Alo Highway, road from Likavali Alo Highway to Lower Siang District Headquarters.
losses, therefore the NIT was cancelled also.
Oh,
Cancelled also.
okay, according to the, in response to the possibility.
Because this writ petition was disposed of in motion itself losses.
No, it was not cancelled. According to them, the petitioner contains as per the date and time fixed for opening of the bid in the NIT data, the bid submitted have been opened. You did open the bid also,
Yes, it was.
but not declare the results. What is the cancellation order?
Page 21 also.
21.
This is
31 March. 31 March. Yes.
because lawsuit this the PW department lawsuit is not the party in the lawsuit arbitration proceeding, the NGT lawsuit. Deputy Commissioner is the party lawsuit. If lawsuits read the page 21 lawsuit order.
Yes, read.
The notice inviting tender invited by so and so. There is so and so port of work constructions road from so and so and so and so. At CG Lower Siang district, which was open on so and so, is hereby is then cancelled by the undersigned in response to the letter that is so and so. Received from the Deputy Commissioner Lower Siang district Likavali, also as per court order that is so and so.
Okay, then what happened to this NGT proceeding? What is the status of the?
It's pending laws.
Huh?
It's pending.
It was listed on 3/2/2023.
Thereafter lawsuit, what happened lawsuit? And I'm told that it's still pending laws before the NGT. And so far order 23/2023 is concerned.
Yes, no. So you get the latest status of this NGT. Because NGT order which you have annexed is 6/1/2023. We took up this case on April, 3rd April. Now order you are showing to this court is 6/1/2023. And the next date was fixed on 3/2/2023. What order passed on 3/2/2023? And what happened thereafter? You get the latest status.
Lawsuit.
After 2 weeks.
Lawsuit.
On the prayer of Mr. Topin, London Council for the petitioner, listed after 2 weeks, to enable him to get the latest status of the proceeding, stated to be pending before the National Green Tribunal. No. East Zone.
Number 18.
Yes.
Lordship, I'm appearing for respondent number 3. I have filed a IA, Your Lordship, was registered as IA number 108 of 2023.
What is the IA?
I'm praying for filing an additional affidavit, Your Lordship.
Where is the IA? Yep. You are for whom? Respondent number 3, Your Lordship, Pasigat Smart City.
Toki for whom?
I'm for 4.
Who is for?
The contractor.
Contractor. You are for the petitioner.
Yes,
You wanted an adjournment.
yes, my lord.
You want to file an additional affidavit?
Yes, Your Lordship.
Yes. You are for?
I'm for 3 and 4 in IO. In main petition, I'm for 1 and 3.
Yes. Pasigat City.
Yes,
Smart
Lordship.
City Development.
Yes.
You are Mr. S. Dev.
T Marngar.
T.
T Marngar.
Marnor.
Marngar.
All right. Within how much time you will file?
Lordship, if it may be listed on the 18th, Your Lordship, of August.
18 of August.
Yes, Lordship.
Yes, 18 of August.
18 of August.
In IA 108. Heard Mr. T.
T Marngar.
Ma'am, this, Your Lordship, I will be filing an affidavit in the main petition.
Who is preventing you from filing an affidavit? You file. Mr. No. This is an application. Taking leave of this court to file additional affidavit in WPC 13 April 2023. Leave sought for is granted. Applicant may file. Applicant who is respondent number 3
Yes, Lordship.
in the writ petition in WPC 13 April 2023 may file additional affidavit within 2 weeks. I understand.
If it may be listed on the 18th, Your Lordship.
So, it's grateful and council for the parties listed on 18th of August. Okay. All right, 18th of August. Yes, 19 and 20. This is again a smart city.
Yes, Your Lordship. In this case, Your Lordship, we have filed our application for implement. However, on the last date, Your Lordship, Sir's colleague has appeared and gave no objection to the same. However, Your Lordship, predecessor has observed that there is no provision of law in the petition. She has advised us to file a proper application. However, Your Lordship, today I'm in the prayer that if Your Lordship may kindly allow us to withdraw the same with liberty to file a fresh, Your Lordship.
Which one?
The IA 69 of 2023, Your Lordship.
You want to withdraw the IA?
Your Lordship, with liberty to file a fresh, Your Lordship.
What is this IA for?
IA for pleading as a respondent in WPC 54 of 2021, Lordship.
Simply the applicant as a respondent in WPC 54.
You know, the basic challenge was that similarly situated person was given land allotment and I was not given. And then the smart city, the DC cum chairperson of the smart city issued an impugned order vacating. So that was put into challenge. And the deputy commissioner and the chairperson of the smart city of a district is something different. So then 2 person assuming one position and then the defect in the IA is that they have not invoked any appropriate provision. So let them withdraw it.
He wants to be what? This application is for what?
Implement as a
Implement as
responsible.
a party in the case, Your Lordship.
You want to be a respondent in WPC 54?
Yes, Your Lordship. Yes, Lordship.
And now they are praying it. I have no objection. Let them withdraw.
With a liberty to file a fresh, Lordship.
All right. Mr. T. Magner.
Yes, Your Lordship.
And the council for
You are a
applicant
councillor.
seeks to withdraw this application with a liberty to file abrasive advice. With petition, in view of
At
the
least after 4 weeks.
Your Lordship, if can be again on the 18th, Your Lordship. So easy.
No, no, I
actually.
will not be there.
interlocutory application.
Implement.
This is dismissed on withdrawal with a liberty as above.
After 4 weeks, the main.
Lordship,
You
we can be on the same day.
No, no.
If kindly accommodate the Lordship. What are you challenging here?
Basically, I am challenging on 2 counts.
You are not a party, yeah? Yeah, I'm not yet a party to the case, Your
So
Lordship.
you cannot make a prayer.
So
Sorry,
you can make a prayer. All right.
let's start.
Your Lordship, 4 weeks.
Interim order to continue.
Okay, in the will process will continue to next.
Grateful.
Your Lordship, in this case, similarly, I file an IA for praying leave of the court to file additional affidavit, Your Lordship.
We don't have any objection on that.
Oh. I 107. Yes, Your Lordship.
You are which respondent?
Respondent number 3, Your Lordship.
Oh, same order. I 107.
Yes, Your Lordship.
Dispose. What is IA 71?
There's no more IA in this case, Your Lordship. This is the only IA.
Oh, this is disposed of. Oh, okay, all right. On 18.
Lordship, it can be on 18, Your Lordship.
Huh?
18 August.
Yes, on the present team on the, this is on 18. Point 1072. No, not withdrawal. That is for filing of an additional affidavit.
107 for filing additional. But
That
the
was on additional.
previous
order.
item number is for filing a fresh. Highly obliged.
Deeply obliged.
Lord, I am on behalf of Sultana as instructed me to sort adjournment.
You are on behalf of
M. Kato, DIGI.
M. Kato. Kato.
No,
No, my lord, I am for the M. Kato.
Okay.
Responsibility.
I am for N Sultana.
This is which
Item 23.
item 23.
Yes.
What is this matter about?
This
Which
matter is about the that service matter.
Ah,
Petitioner has been discharged from the service on the ground of that I Vijayan has lost.
okay. When do you want?
9th of August. As the council comes from outside the state.
Of August.
My lord, council has instructed me to get 9th of August because he comes from outside
21st of August.
of life.
21st is okay.
Okay.
On the prayer of the council for the petition, list it on 21st of August.
Of life. I'm
Yeah,
correct.